May I please, my lord?
Yes.
My lord, we take concern from the other parties, my lord. I like to mention item number 11 on behalf of M. Kato, my lord. Due to some personal difficulties, he is out of station.
Item 11.
Yes, my lord. Hi.
Mr.
Ensora.
Parent Council submits that Mr. Kato has some personal difficulties today. Therefore, he prays for adjournment. He has also obtained consent from the Land Council for the petitioner. Staff A is prayed for, comma. The matter stand adjourned for 2 weeks.
3 weeks, my lord.
3 weeks.
Yes, my lord.
Okay, staff. List the matter after 3 weeks.
For the petitioner, Your
Oh, you are for the petitioner?
Yes.
Okay, then Mayor, pray for adjournment to which Mr.
Ditatat.
Land Council for the petitioner has no objection. Prayer allowed. List the matter after 3 weeks. Okay.
Deeply obliged.
May I please, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 1, Your Lordship. Your Lordship, the Learned Council
Item
1, Your Lordship. Motion stage, Your Lordship. Your Lordship, Learned Council SK Das.
Hmm.
He is from Gauhati, Your Lordship. Due to some personal difficulty, he could not turn up today, Your Lordship. Therefore,
when do you want?
day after tomorrow, Your Lordship.
As prayed for by Mr.
E. Menjo.
on behalf of Mr. S.K. Das and council for the petitioner who is stated to be having some personal difficulties, comma, list the matter
Day after tomorrow, Your Lordship.
on the other tomorrow would be 26.
26.
Okay.
Hello.
Item number 2.
May I please, Your Lordship?
Yes.
Your Lordship, here petitioner is assailing the impugn order dated 22/7/2026, Your Lordship, passed by the Learned Session Court 0, Your Lordship, whereby the Learned Session Court has framed charges under section 108 of VNS against the accused person, Your Lordship.
Yes, Mr. Rath, have you seen the order?
No, my lord, I have not gone through it, my lord.
Oh, I think some inherent difficulties in the order itself appears.
But only single section में वाइट है, ये section में वाइट. My lord, if my lord prima facie find, my lord, that there is some illegality, my lord, then my lord, notice may be issued and the further proceeding may be stayed, my lord.
It has to be.
Yes, my lord, because in revision, if it is apparent to your lordship,
Is
then
that
it
right?
has to be in the, yeah.
Because one way, he says that if what's no direct evidence. After framing of charge,
Yes, my lord.
how discharge petition will be heard?
Yes,
The discharge petition is to be actually
Yes,
first
it
disposed
has to
of.
be precise, the
Yeah.
framing of charge.
After that only the charge can be framed.
Yes, absolutely, my lord.
Hmm.
Absolutely correct, man. So if it is apparent, my lord, then the revision, under the revision jurisdiction, my lord can always interfere, man.
Mhm. But we'll not set aside at the
Yes, my
motion
lord.
stage.
Yes,
Just
ma'am.
issue an
Yes, yes, ma'am.
Hard, Mr.
E. Menjo, Your Lordship.
Land Council for the petitioner. Also hard, Mr. PAT Land additional PP for the state staff. Para. This criminal revision petition under section 438, read with section 442 of the Bharati Nagarik Suraksha Sanhita is directed against the order dated 22/7/2026 passed by the Learned Session Judge 0 in session case number 15/2025 within bracket Z Colorium PS case number 6/2025. Whereby while framing charge. How many accused are there
1 year. Petitioner.
against the accused? The land assessment, no, just, that's all, huh? Thereafter, the land counsel for the petitioner submits that the land assessment, the land trial court, while framing charge against the accused for offense under section 108 BNS 2023,
My lord, the
is
order,
directed.
my lord, the order apparently illegality is from page, my lord, 87. This may be quoted, my lord. Thus, this court instead of discharging, my lord. The court just want to confirm. Thus, this court, instead of discharging the accused person at this stage, as prayed by the defense counsel, would like to hear the informant and the investigation officer.
There's
For
someone also, someone.
Yes, my lord.
Ah.
Someone also, but charge has been framed, my lord.
Yes, Your Lord.
Very
That is
strange,
right,
my
that
lord.
is
Yes, my
right.
lord. This, specifically this portion onward, my
Ah.
lord, is need to be, my lord, interfered with, my lord. Because either if court find that there is a grave suspicion, then charge has to be framed. If not, my lord, then entitled to be discharged.
Because this will amount to mini trial,
Yes, absolutely.
calling, summoning them,
Yes, my lord.
asking them, this will be mini trial.
Yes, my lord. But, my lord,
Uh,
well, the charge is again framed, my lord.
Charge already framed again. So this will be mini trial and then
Yes.
a trial before trial.
Yes, trial before trial, yes, my lord.
Hmm.
Double trial, man.
Whereby the learned trial court, while framing charge against the accused under so and so, huh, has someone. He issued someone. Decided, huh? Court has decided to issue someone to the investigating officer of the case along and the informant. So where it was decided that he will examine, however, the chosen.
My lord,
Page 88, Your Lordship.
but here he says, however, the charge under so and so has been framed, my lord. Prior to that, my lord, the preceding paragraph says the court want to confirm it from the informant and the investigation officer. Now here the charge.
Confirm in which paragraph?
Or paragraph, my lord, before, my lord, however, thus, this
Okay,
court,
thus, okay.
instead of discharging.
Stays at a defense of counsel. Okay, to here,
Yes, my lord. My lord, till last, my lord, list on so and so for prosecution evidence,
Mhm.
again, on last page, my lord.
Okay, no, this is for prosecution evidence again.
Yes, my
Your
lord.
Lordship.
So many things.
Yes, many irregularities, my lord, illegalities are there, my lord. It's not merely an irregularity, it's an illegality. Apparently.
The order said to confirm.
Yes, my lord. My lord will find, thus, this court, instead of discharging the accused person at this stage, as prayed by defense counsel, would like to hear the informant and investigation officer for passing appropriate order on next date of hearing.
Okay.
And then it comes, however, the
Yeah.
charge under so and so has been framed.
Mm.
against the accused person today. The said charge has been read over, my lord, meaning thereby there
Yes,
is
yes.
no sufficient
yeah.
material actually. my lord.
Okay. Instead of recording sufficient material
Yes,
to
my lord,
frame
more
charge.
than suspicion.
Okay.
Sorry, more than, my
Okay.
lord, yes.
So,
Strong evidence.
what was the
Strong
last, investigation officer? Okay, on the question of charge. Discharge,
Yes, my lord.
okay. Stop, huh? Okay.
Basically, my lord, the learned court has exceeded its jurisdiction actually, my lord.
This is accident,
Yes, my lord.
exceeded.
Yes.
So many things. In one small order, so many defects. Okay. You should notice. Will not make any observation now.
Yes, yes,
Just stay,
yes,
huh?
my lord, my lord.
You should notice. Stop, since Mr. There is also private respondent.
Yes, your lordship.
Okay. At the Learned Edison PP has accepted notice, no formal notice need be, is required to be issued to the state respondent staff. The petitioner shall take steps for service of notice upon the respondent number 2 by a speed post as well as by usual process within 2 days from today. Staff, Sarah. List the matter. And then a call for the scan copy of the trial protocol. Staff, and list the matter. When? Next week?
My lord, whether this service will be completed or not.
Complete, there is a private respondent
Yes,
also.
Yes, my lord.
3 weeks.
3 weeks, your lordship.
Okay, then we'll get listed in the second one.
After 3 weeks, fixed date, my lord.
No, 14.
Okay, my.
Okay.
14th of September.
Your lordship.
Is it-
stay of press-
Hmm?
stay of proceeding.
Stay of proceeding,
Stay
my
of
lord.
proceeding, your lordship.
Yes, 14, huh? Stop, huh? Tara. In the meantime, having considered the impugn order, and then having considered the contention and the submission made by the Learned Counsel for the petitioner, and on perusal of the impugn order, comma, it is provided that the further proceeding of the which case session case
Number
number
15.
15 2025
corresponding to Colorian.
within bracket Z, huh? Arising out of in Colorium PS case number 6 2025 shall remain state till the next returnable date. Okay.
Okay. Deeply obliged.
Item number 3,
Please, Lordship.
Yes.
Your Lordship, this is a pre-arrest bail, Your Lordship.
Hmm.
Filed under section 482, Your Lordship. This case is regarding the cattle thief case, Your Lordship. Cattle
Okay.
thief, Your Lordship, and illegal transportation of the cattle, Your Lordship. And during the time of transporting the cattle, Your Lordship, the vehicle ran the Naka party and
Yes,
causing
yes.
injuries to the police personnel, Your Lordship.
Whether
However-
there was some other case, some in connection with this, I think more than one accused,
Yes, my lord.
Yes.
other accused person probably also approached the court,
Yes.
whether granted or not in that case.
Not granted, my lord.
I'm not aware, Your Lordship.
Not granted by the
However,
coordinate
Your
bench.
Lordship, here in this case, Your Lordship,
Hmm.
the name of the accused person is not mentioned in the FIR, Your Lordship. Even he was not there at the place of occurrence, Your Lordship. Even moreover,
He was not present in the vehicle.
yes, Your Lordship.
Okay.
Only his name was surfaced during the investigation on the basis of CDR analysis, Your Lordship,
Mhm.
which shows that the accused, the petitioner, telephonically contact with.
Where do we find that? Your submission, where do we find that?
Uh, Your Lordship, most of the accused persons who are arrested in this case, Your Lordship, already granted bail.
They were granted bail only after their arrest only.
Yes, Your Lordship, and during,
But in your case, you have not yet been arrested.
yes,
When the FIR was lodged?
it was lodged on 30 April 2026, Your Lordship.
April,
Yes, Your Lordship,
not yet arrested.
not yet arrested. Yes,
Absconding.
You are from Assam.
yes, Your Lordship.
You are from Assam.
Yes, Your Lordship. May I kindly come to page number 20.
See, from April, he should have been arrested by now,
My lord, he's absconding, my lord.
absconding.
Absconding. And my lord has earlier, before this matter was, before your lordship only on 1/7/2026, my lord.
Mhm.
The same applicant, my lord.
Mhm.
So whether they have disclosed this aspect or not, my lord, because this court has already considered this application, my lord.
Okay,
In anticipatory bail number 75 of 26. Same, Sarifukul alias Akulukan, same, my lord. Same applicant, my lord.
what order was passed in that case?
That was withdrawn, Your Lordship, because the criminal accident we did not.
Okay, criminal antecedent.
Yes, yes.
Where have you stated now?
18, page number 18, Your Lord, paragraph 18, page number 11, Your Lordship.
Paragraph?
Paragraph 11,
18.
Your Lordship, page number 18.
Okay, there is a case against you.
Yes, Your Lordship, what happened here in this case, Your Lordship? Your Lordship, on 30.
Okay, similar nature of case.
Your Lordship, on 30 April 2026, Your Lordship.
That is also under investigation.
Yes, Your Lordship, actually what happened, Your Lordship, the accused persons stole the cattle from the Poma area, Your Lordship. And the owner of the cattle subsequently lodged an FIR before the Palijan PS, Your Lordship, on the same day, Your Lordship. And
Hmm.
Your Lordship,
Same day, in this case only.
yes, Your Lordship, this,
In that case also, he has not been arrested.
yes, I'm also filed the anticipatory for that section also, Your Lordship, on that case. There is item number 4, Your Lordship.
So that case and this case, according to you, is same,
Same, Your Lordship.
arising out of the same incident.
Incident. Actually, what happened here in the case, Your Lordship,
Huh.
the Balijan PS is lodged by the owner of the cattle, Your Lordship.
Okay,
The missing.
okay, this and here it was lodged by the police also.
No, but by the owner, Balijan. But while they transporting the cattle from Poma to Assam, Your Lordship, they ran the Naka party.
That is what I'm
Your
saying.
Lordship.
That was by the owner, and this FIR was lodged by the police.
By the police.
Oh, okay.
Yes. So while they
Yes,
transporting the
that is
cattle,
separate cause of action.
Yes, separate cause of action.
however, in both the cases, my name is not reflected, Your Lordship, and even I was not there. My name was surfaced only during the course of investigation on the basis of the CEDAR analysis.
But in this case, probably if he was not in the vehicle,
My lord,
It's
he's
not
the,
involved.
my lord, I have perused the case diary earlier. He is the mastermind in this case. My lord,
Okay.
FIR are normally registered.
but then in the RAM case, he is
Yeah,
not a mastermind.
normally registered, my lord, when there is
But in the same
credible
case, he may be.
information, but
Mm.
FIR is not registered after investigation.
Mhm.
During the course of investigation, only his name was pop up, my lord. So, my lord, what my humble submission would be at this stage, my lord,
Mm.
no interim protection after perusal of the CD, my lord, his bail may be considered in both the cases because, my lord, he is not only involved in this
The
case.
other
my lord.
case is also here.
Yes, my lord.
You have filed anticipatory for the other case also.
Balijan also, Your Lordship.
In other case,
Yes, my lord.
because he is the mastermind,
Yes, my lord.
it may not be possible.
But-
then here in this case, because it is a case, this is
Chimpu case.
registered under,
Chimpu.
no, just a minute, the offense includes what?
One of the, my lord, the police official was also injured, my lord, seriously injured. He was.
But he was not present.
Yes.
He was not in the vehicle.
Yes, yes.
My lord, but the master, he's the mastermind
No,
behind all this.
master-
He's
even if-
smuggling case, my lord. Cow smuggling case, my lord. It's not a simple case, my lord.
Okay.
All over Northeast, my lord, is there, my lord. My lord, after perusal of the case diary, my lord, what my humble submission, even in this case, my lord, after perusal of the case diary, my lord, may kindly consider his prayer, my lord. Let it be on, my lord.
Your Lordship, my prayer is that, Your Lordship, if
See,
the court finds only.
how it will help you, even if this court grants interim anticipatory bail in this case, in the other case, it will be difficult. The other case, you are mastermind there.
Your Lordship, that is the,
Let us-
that's the allegation, Your Lordship. That is more, that was not proved, Your Lord.
Okay.
That was.
Let us see the
after
record.
proper trial, Your Lordship.
Let us see
Yep.
the record to ascertain. Yes.
Lordship,
Okay.
Your Lordship, if this court finds any prima facie against me, Your Lordship, then this court has vacated my interim.
Just a minute, huh? Let us see the FIR once.
And my lord, there are other in other, my lord, bail application, there was observation by this court also, which was not the part of the record. They supposed to annex all this order, my lord, where, my lord, the earlier other accused bail has been rejected, my lord. So as to guide this court, my lord. He is not even annexed the earlier bail, my lord, withdraw order, my lord.
Your Lordship, that was, I was not part of that case, Your Lordship, because I never ever, that the other co-accused person file a AV.
No, in which case you withdrew? Which case the bail was withdrawn? In this case? What is this 61? 61-2.
I will,
Like counsel for the petitioner.
section.
61 is criminal conspiracy, Your Lordship.
Okay, 109.
109 is attempt to murder, Your Lordship.
132.
Assault or criminal force to deter the public servant, Your Lordship.
Okay, 132.
Voluntary causing harm, Your Lordship.
12. 121.
133, Your Lordship.
121-2.
121, voluntary causing harm, Your Lordship.
Okay. 303.
Punishment for theft, Your Lordship.
Theft also involved here.
Yes, my lord. Theft is
I
also
think it's,
involved.
hmm.
And triple one.
Because for theft, a separate case has been registered. But then if had that not been registered, this of course will. But then both are connected in with the street 111.
Organized crime, Your Lordship.
See, my lord,
Okay.
organized crime, the
Yeah,
section, my lord.
34, no? And then 11(1)(d) of cruelty. Okay.
And 11D, my lord, prevention of cruelty to animal.
Right.
And 184, 187 of MB Act as well, madam.
MDH also.
Vehicle is also involved, madam.
Okay.
But only my limited prayer, so that I bring into
Don't
the
worry.
record.
Here in this case, you'll be protected later on also. But then in the other case, since for the same person, you have filed two applications. In the other case also, record would be necessary to examine, to ascertain. Will issue notice?
Your Lordship, in other case, Your Lordship,
Sorry, full.
I think
In
only
this,
303 is attracted, Your Lordship.
Hmm?
303 is attracted only, because it's only theft, but other is not
Okay.
attracted to the activity.
Here in the second case, item 4, have you disclosed the antecedent?
Yes, Your Lordship.
Which paragraph? Okay, 13. Okay, hard, Mr.
Speak up, Your Lordship.
Land Council for the applicant. So also hard, Mr. Edger. Land Council, land additional PP for the state staff. Ara. By filing this application under section 482 of BNSS 2023, the petitioner is seeking pre-arrest bail in connection with Chimpu PSK. This is Chimpu
Yes, Your Lordship.
PS case number 33/2026 under section 61(2), 109, 132, 121, 3052, 317(4), 111(3), and 5, within bracket 3, within bracket 5, BNS, read with section 11D E of prevention of cruelty to Animal Act and Section 184 stroke 185 87 of MV Act. Stop, huh? Para. Call, issue notice. Call for the scanned copy of the case diary. Stop, list the matter. Next week.
Yes, my lord, any date, my lord, any date.
Your Lordship, protection may be given, Your Lordship, because Your Lordship, because I'm the earning member of my family also. And I have the responsibility to maintain them, Your Lordship.
My lord, this matter,
If this court finds any prima facie case against me, Your Lordship.
Just a minute. Okay.
This court has.
Yeah.
this matter came up thrice, my lord. This is the fourth time, my lord. Even in that case, my lord has not extended interim protection in this case. So, my lord, may kindly,
Let us see the record.
yes, my lord.
How it will help you, Learning Council?
Yes, Your Lordship.
In the other case, I'm not going to grant you because the other co-accused person were also not granted. You are absconding since April. Here, even if I grant also, we need to see the record because you have not also disclosed. We need to see the record. Let us see the record. Why you are forcing? When you know that it's not going to help you,
You know,
how it will help you?
at least protection may be given.
What protection?
Interim protection, Your Lordship. At least so that I can.
Learning Council, here in this case, you are not going to be protected. In the same case, same person, in one case, after perusal of records, you will be protected here in this case if you are really not involved in the RAM case. The court is also inclined now, but then since the record need to be seen, you have not also disclosed the earlier bail application also.
I have disclosed that, Your Lordship.
Okay, least matter.
Third lordship.
Hmm?
Third
Third,
lordship.
okay, 3rd September. Similar order, but then
Case number different, my lord.
police,
And police
yes,
station also
case would be
different.
different, huh?
Yes.
Same hearing, same counsel, huh? But then the apprehending his arrest in Balijan PS case number 16, 2026 under section 302 within bracket 2, 325 stroke 3 within bracket 5 of the BNS 2023 read with section 11(1)(d) and 11(1)(i) of the Prevention of Cruelty to Animal Act 1960. Okay, same, huh?
Obliging.
Okay.
All right.
Item number 5.
May Lordship.
Yes.
Lordship, this criminal petition 253/2026 has been filed under section 528 for quashing of the FIR ITA WPS case number 31/2024. Charged under section 498A IPC in GR case 682/2024. Lordship, here in the petition, both the petitioner husband and wife. In the year 2024, on 24/6/2024, an FIR was filed against the husband for cruelty, which was registered at ITA WPS. And since onward, both the parties are living in the same house peacefully, along with the minor child. And they have been aware after receiving the honorable court order for appearance. Now the party have been settled and Lordship in the page number 24 unit. They have settled between the parties and wish to withdraw the ITA WPS case number through this honorable court.
Cannot. At this stage. What is the stage of trial?
Lordship, stage of trial is appearance for the PW. It's fixed on 8th of October 2026.
Trial comment.
Where is that order?
Lordship, page number 22.
22,
Yes, Lordship.
22, not the 23. 22 is what?
23.
It's a 23 only.
23, yes, Lordship.
Yes, my lord. Trial comments, my lord. Now prosecution witness.
Charge framed.
Yes, my lord. Trial already comments only, my lord, because now
Already.
for prosecution witness, my lord.
Okay, not yet examined,
Not
otherwise.
yet examined. Fix on 810. So 810 is
Directed to as to why the summon was not forwarded. Okay. Summon order.
next date is on October.
Okay, 810
Yes, ma'am.
for one or before that stage.
Prosecution witness, my lord.
Positional witnesses.
This is for
Okay,
victim,
let us see this.
victim and my lord, the IO has been summoned.
Mhm.
Minu Koyu and Jimmy Koyu through OCPS. No,
They are
Jimmy
staying
Koyu.
together.
Yes, Lordship. Along with
Where,
one
where,
minor
where do
child.
we find that? Where have you stated that you are staying together?
Lordship, the paragraph 4. The humble petitioners beg to submit that petitioner parties have settled the matter amicably outside the honorable court within the families in the presence of senior member out of own free will without any coercion, undue influence or pressure. And further, the parties wish to discontinue the instant case to maintain their peaceful married life and also to maintain peace tranquility within the parties. As complainant is fully convinced and made consent for the settlement to dispose of the instance case, ITA WPS such and such, GR case number such and such. Is caused by this honorable court, the interrelationship between the parties will constant and any kind of discrepancies won't arise in future, Lordship.
In the agreement, where have you stated? This is your petition only, but in the agreement, where have you stated that you are staying together with the children?
Lordship, in the agreement, paragraph 3, herein the complainants admit that the decision has been taken without any coercion and wish to stay together with jovial life
Okay, not
as
yet staying
usual.
together. Not staying together, that means.
Actually, after filing of this FIR, after onward they are staying together.
Hmm?
After filing of the FIR also, they was staying together till date.
But they say that wish to stay together.
This was drafted by some, but actually they are in the same house, Lordship.
Yes, Mr. Rate.
Yes, my lord.
Notice need to issue or just can grant?
Yes, yes, my lord. Because the next date is for trial.
Yeah.
Yes, Lordship. Along with
And in
7
such
years
case-
old daughter.
We have no idea if in such case, if the wife are under coercion or not. But then whether need to call the call at least the informant,
Yes, my lord. It can be, my lord. The court, this court can direct the.
because we do not know.
Yes,
So many applications are coming,
yes, my lord.
one after another,
Yes, my lord.
comparing that the other case has been
Yes, my
considered.
lord. The informant
So
victim
we
can
do
be
not
called
know
upon, my lord.
what exactly is there.
Yes, my lord. Informant
If-
victim can be called upon, my lord. This is not for the first time. In many occasions, this court has exercised its power, my lord. So as to confirm, my lord, when husband-wife dispute come up before this court for quashing.
So next day is fixed on 10th.
Yes, Lordship. 10 October 2026.
But this kind of a case can easily be granted,
Yes, my
but only we need to confirm.
yes, my lord. My lord, before then, my lord, the victim may be called upon before this court, my lord.
Hmm.
And my lord, this court can interact the victim in the chamber itself, my lord. With proper I card, my lord.
when calling, after calling record also, record will not show anything.
Yes, my lord.
But then only that confirmation, the PP can also confirm.
Yes, my lord. Yes, my lord.
Hmm. Okay, anyway, so, Mr.
And Soki.
Record need to be called, oh,
No, my lord,
not required.
not required, my lord, because the next date
Next date.
for prosecution with the section is 498A only.
Mhm.
No other sections
Okay.
are there.
Well, because in the agreement, the words are not clear.
Yes, my lord.
They are staying together, and then the submission says, submits that their children nowhere recorded staying with the children.
If victim come, everything will be clear, my lord.
Mhm. Okay. Hard Mr.
And Soki.
Planning Council for the petition, also hard Mr. Ete. And 88 Rana additional PP for the state staff para. This application under section 528 of BNSS 2023 has been jointly filed by the accused, sorry, the informant and the accused. Praying for crossing off the, where is the GR case number 682/2024 arising out of ITA women PS case, PS case number 31/2024 under section 498A IPC on the ground that the matter has amicably been settled between the parties. Staff para. Mr. At the additional PP. Surely submits that in order to ascertain the fact of the amicable settlement between the parties come, the parties may be summoned by this court to ascertain party may be summoned to appear, summoned to appear before this court. Staff. Okay. Issue notice. The parties,
Yes.
both the parties or the only the
My lord, the
accused
victim,
has nothing to do.
yeah, victim was petition number 1.
Hmm.
She is the wife.
Okay, the petitioner number, the petitioner number 1 shall appear before this court when?
My lord, on Friday, 28,
Friday, okay.
this 28.
Before this court on Friday, 28th.
With proper I card, my lord.
Okay, with proper identity card, huh? So, okay. List the matter on
28, my lord.
28. Okay.
Obliged, man.
Much obliged.
Item number 6.
Email petition, my lord, under section 528. Jointly filed by the petitioners, my lord. Petitioners 1, 2, 3, they are the accused, my lord. Petitioner 4 is the victim, minor victim. And petition number 5 is the mother, and pro mother, this petition has been filed. My lord, seeking quashing of the FIR dated 30/2/2026 and the consequent charge sheet number 27, registered section 10 and 12 against petition number 1 and 2. And petition number 3, not charged under section POCSO, but section 75 of the Juvenile Justice Code. It's a case.
What is 74?
Step-
Argument advanced by so and so on a query made by the court as to why the chief secretary to the government of Andhra Pradesh as well as the commissioner secretary have not filed their affidavit. It has appeared to us whether the chief secretary and commissioner were either not properly instructed by the court. Then said in that view of the matter, the chief secretary to the government of Arunachal Pradesh as well as the commissioner secretary, the government of Arunachal Pradesh are hereby directed to file the affidavit answering the question framed for determination by this court in the order dated 14/9/2021 and 9/8/2021. This is specifically directed. Such affidavit by the chief secretary and the government of to the government of Arunachal Pradesh as well as the commissioner secretary DA shall be filed within the so and so. Where is the affidavit?
Lordship, can it be taken up at 2, Lordship? I'll
At-
sort out.
At 2. At 2, I think we have a
Because
election argument matter.
That's it.
Okay, so I have seen they have not filed.
Actually, it was filed because
It was filed by, not by the chief secretary, but by the court has also taken note of that. It was by joint secretary. Additional affidavit filed by joint secretary only. This was not accepted. Court saying that order dated 9/8/2022 leaves no manner of doubt that the affidavit is required to be filed by chief secretary and the commissioner and secretary GA. That probably has not yet filed.
Lordship, I was under impression, Lordship, it was already filed because there are some analogous matters are there, Lordship,
Mhm.
along with this.
Okay, then you sort it out then.
Therefore,
Okay,
Lordship,
okay. But then whatever maybe, even if that is there also, but this need probably a little longer hearing, long hearing. It need to be fixed for hearing only,
here actually the issue is very limited.
limited.
The issue.
No, the appointment of the GA also, the GB and head GB also.
HGB.
In the under section 5, it doesn't mention GB or head GB.
HGB.
It only mention village authority, but under which provisions of law? It has been the GB and head GBs are being appointed. And then three guidelines or the laws under which, because the AFR doesn't provide that, provide for framing of rule or regulation. So under which provision it was provided. So these questions probably, although it looks like only if it is only with the appointment, with regards to the appointment of the GB, leaving the senior, that of course is a very small, can be settled. But then the larger question here, the issue has already been framed.
Then kindly it may be taken up day after tomorrow, Lordship.
It can be, but see, just for the issues, I'll just read out because it requires whether there can be any guidelines framed by the government for appointment of the GBs, head GBs at all. When section 5 of the Assam Frontier Administration of Justice Regulation 1945 empowers only the deputy commissioner of the district to appoint, remove the village authority as distinct and different from GBs, head GBs or not. Next is under which provision of law the nomenclature of GBs, head GBs have been coined while appointing as such, which has been further interchangeably used to mean the village authority as per section 5 of the Assam Frontier Administration of Justice Regulation 45. If at all, the government has the power to frame the guidelines either for appointment of a GB or head GB, then which is the guidelines framed by the government for making such appointment, and under which provision of law they are thus appointed?
Law.
So this involves, I think, larger questions.
Larger question as well. So they are the promoter lawsuit.
Okay. But Mr. Lawyer for Land Council for the petitioner also had Mr. Tapin, S. Tapin, Land Senior Government Advocate for the state respondent, and Mr. Lawling for the private respondent staffer. On the prayer of Mr. Tapin, let this matter, Mr. Tapin, Land Senior Government Advocate, let this matter be listed again on, Lordship?
Day after tomorrow, election petition is there.
Okay, then Monday,
Evidence, Lordship.
Thursday,
Thursday also there, Lordship.
okay, Thursday,
Friday.
Huh?
Friday is better.
oh, Thursday is DB day. Friday,
Friday.
okay, Friday, let us see on Friday. Okay.
Item number 8.
My lord, in this case, I appear for respondent 4 NHPC. My lord may see the last order of 6th of August.
Item 8.
Yes,
Hmm.
I appear for respondent 4 NHPC. Our affidavit in opposition is there. Lordship may see the order dated 6th of August.
6th August.
Yes, the last order by Justice Nair.
Two and three.
Yes, a lot.
So, my lord, I have not received any affidavit so far. So far as the state is concerned, I have not received any affidavit. I don't know whether they have
Your
filed.
Lordship,
Have you filed?
yes, for respondent number 1, we have filed, Your Lordship. For respondent number 2 and 3, we are yet to receive our paravised reply. So at least 3
My
weeks
lord,
time will
in
be
that
granted,
case,
Your
my
Lordship.
lord, in that case, they should at least give us a copy of the affidavit in opposition filed for respondent 1. That could be handed over to my
One-
junior.
Your Lordship, we have,
One, have you?
before
have you
filing, Your Lordship, we have to, we used to hand over, Your Lordship.
Hmm?
That is for 2023, Your Lordship.
No, the respondent number 1, you have not yet handed over the copy of
No,
that.
Your Lordship, before filing, Your Lordship, I think we used
It
to
was
hand
handed over.
Yes, Your
No.
Lordship.
But they are
It was not handed
asking for
over.
copy.
Possibly it was given only to state. It was not given to NHPC. NHPC has got an important
Your
role to
Lordship.
play.
Okay, Your Lordship.
Okay. Mr. You are for petitioner.
Yes.
My lord, I am for
Okay.
respondent 4 NHPC. And we have
Respondent
an
number 4.
important role to play. Yes, respondent 4.
Hmm.
Our affidavit in opposition is there.
Who is
But
you are for
our-
petitioner?
Yes, sir. For the
Okay. Mr.
M. Kaso, only.
Land Council for the petitioner. Ms. Pango, Land Government Advocate for the state respondent submitted, although she has filed an affidavit on behalf of the respondent number 1. She is yet to receive instruction in respect of the respondent number 2 and 3. And therefore she prays for how much time?
At least 3 weeks time may be
Your
granted, Your
Lordship,
Lord.
It was supposed to be listed for disposal today.
Will be at liberty to file.
Last paragraph, Your Lordship. Order dated 6th of August 2026.
Have you seen the last order, Ms. Pangu?
Yes, Your Lordship, but in this, that last order, Your Lordship, I have not appeared, Your Lordship, in this matter.
And Singapore 6th of September already.
6th of September. Okay.
6th September will be difficult. I have a problem because
Sorry.
ultimately the money, if the writ petition is allowed, it is we who will have to execute the order. So therefore, my lord, we have a very important role to play. 6th
Upon
September is
consideration,
Sunday.
the rest. Okay, the Lana
This
government
could be
advocate
listed
is
on 7th
granted
of September.
one more last opportunity to file affidavit in opposition, to obtain instruction and to file affidavit on, in respect of, on behalf of the respondent number 2 and 3 staff. Grant 3 weeks, huh? Okay. Staff.
But my lord, observation may kindly be made.
Staff, Ms. Pango shall furnish a copy of the
Yes.
affidavit in opposition file on behalf of the respondent number 1 to the Lana Council appearing on behalf of the. Have you received?
Yes.
Okay, the copy also to be furnished, huh, to the Lana Council appearing on behalf of the respondent number 4.
4,
Yeah, for
yes.
respondent number 4. Okay,
NSPC.
within 3 days from today.
Your Lordship.
Okay, stop. Requested, come list the matter again on when? When can we fixed?
My lord, I have no
7.
difficulty. If it is 3 weeks, let it be 3 weeks or whenever it is, they should file affidavit. It is better for all of us.
14, Your Lordship.
40, is 14 okay?
14, Your Lordship.
14,
Let me just see, my lord. Let me just have a look. Let me just.
okay, 14
My
September.
lord, I'll just kindly, my lord. 14th of 14th is Monday. My lord,
Yes,
could it be, my lord, because she prayed for 3 weeks time. The 3 weeks will be, my lord. It could be, my lord. Let it be on 18th. 18th.
Okay, Your Lordship.
18th.
18th of
Okay,
September.
Okay, Your Lordship.
okay, list the matter again on 18th. Okay.
Obliged, Your Lordship.
Item number 9.
My lord, this is also criminal petition, my lord, section 528, my lord, BNSS, corresponding to 482. Here, basically, my lord, the petitioner is seeking passing of the first information report, my lord, registered as SIC Vigilance Police Thana case number 13 of 2024. So and so, my lord. Basically, the ground is, my lord, ground is twofold, my lord. First ground, my lord, is that from the FIR itself, my lord, there is no disclosure of any commission of the offense by the petitioner, my lord.
Probably the respondent was to clarify whether is it the same or that, or by way of filing additional affidavit, probably you need.
No, my lord, thereafter, my lord, the records will call for, my lord. The
Okay.
is here, my lord, and the trial court records is also here, my lord.
Okay, so.
And then on the last occasion, my lord, I have shown the instruction, my lord. It's with me. It's now, my lord. My lord can peruse it, my lord. It seems the query, the specific query made by my lord, that whether
Specific?
there was any specific query, my lord, as to whether order dated 1/7/2026, my lord. Written instruction regarding whether the amount alleged to have been misappropriated in the first FIR, which is 2016, my lord.
Order dated
1/7/26, my lord.
17.
Yes, ma'am.
My lord, on earlier occasion also, my lord, in my lord's similar circumstances, my lord, this honorable court, my lord, had already, my lord, passed the second FIR, my lord, and my lord, when the order was passed that this second FIR should be make part of the first FIR in respect of which the charge sheet has been filed, my lord. This is the third FIR. Second FIR has already been passed by this honorable court, saying that should be the part of the first FIR only. So here, very interesting. But in second FIR, although there was some allegation against me, particular specific allegation against me, saying that I was involved in the misappropriation of 5 crore rupees in the second FIR. But this honorable court saying on finding that in the first FIR, my lord, during my tenure, when I was discharging the function as the administrator of my lord, Arunachal Pradesh Apex Cooperative Bank. The allegation in the first FIR, my lord, during my entire tenure, altogether 71 crore rupees were alleged to have been misappropriated during my tenure. My lord. The investigation was carried out. Charge sheet has been filed, my lord. Charge were framed, my lord, but I think stayed by this honorable. Yes. But further proceeding has been stayed by this honorable court. So far, this first FIR is concerned. My lord. Now, my lord, very interesting. Then second FIR was registered, saying that out of 71 crore, 5 crore again separate FIR was launched as a second FIR. And I immediately put to challenge the second FIR before this honorable court. And this honorable court was pleased to quash the second FIR, saying that since 71 crore, it includes 5 crore also. Now, during my tenure, my lord, for suppose 71 crore altogether is the allegation during my entire. Now, my lord, 71 crore investigation charge sheet file, my lord, for every 5 crore, 10 crore, 2 crore, 3 crore, every 4 within that 71 crore, there can be a different criminal proceeding, that 71 crore will be there also, and within then 71 crore, there will be a different proceeding. That's why, my lord, this honorable court set aside and passed this 5 crore allegation, my lord. It is second FIR. Now, this third FIR, even there is no allegation against it. This allegation, third FIR, is basically against the proprietor and who is not now the present sitting MLA, my lord. And my lord will say this is completely a politically motivated FIR. And this FIR is against some other branch manager, my lord. My name is nowhere there, no whisper. And my lord, last occasion, I think counsel for the informant even very candidly and honestly made the submission that there is no allegation so far against the petitioner concerned in the third FIR, my lord. But what the investigation has done is that though there is no whisper in the FIR about me, but they went to the respondent, they went to the concerned authorities seeking prosecution sanction against me, my lord. That's why, my lord, I have approached this honorable court for setting and quashing so far case against me is concerned, my lord, not for the other accused person whose names are there, my lord. Now, my case,
By what way you have been implicated in this third FIR?
now what's in the present FIR, my lord? The
present
reason,
FIR.
my lord, it seems the police is saying that this 19 crore, which was sanctioned to this
Not a part of 73 crore
71 crore.
or 71.
Yes.
19 crore is also part of 71 crore.
Yes, my lord. During my entire tenure, only 70 crore was alleged to be misappropriated. So this 19 crore is literally the part of the 71 crore only during my administration. And very interesting, my lord, here is in the FIR, my lord, may I take to the FIR first. And
In the same bank.
my lord, yes, my lord.
Okay.
I served as an administrator once only, my lord, during the time when the bank was not was trying to recover from its situation, my lord, at that point of time. My lord. Now, in this case also, my lord, what happened? Through Lok Adalat, this particular liability has been settled with the bank, even of this particular FIR, my lord. Liability has been settled through the Lok Adalat.
19.
The 19 crore. This settled, and I think some payment have been made also, my lord. My lord. So this is the case, my lord, completely. And my lord, FIR, my lord, may I take to the FIR, my lord, first. Now, impugn FIR, my lord, will find. My lord, first I will take this, yes, my lord, impugn page number 33, my lord. And once, my lord, if prosecution concedes, this is a part of the same 71 crore, my lord, nothing remains, my lord. And otherwise also, my lord, law says, even if they say that, no, this is not a part of the 71 crore, even then, my lord, law doesn't allow registration of subsequent FIR, my lord, when the allegation, this total allegation of the first FIR is already there. My lord, may I page number 33, my lord.
Just a minute. Yes.
Yes, my lord. It's 8 January 2024, my lord.
Yes.
And my lord, this date is very important because 25 was the election, last general election, my lord. So I will disclose, my lord, how this is motivated, my lord. Complaint against Sri Yura Tagang. This is against Yura. My name is Dr. Olik Taring, my lord. Nowhere my name is there. Complaint against Sri Yura Tagang, then bank manager Itanagar Cooperative Limited, and Sri Hayang Mangfi, Honorable MLA 9 Changdoje Assembly is coming up for issue of false certificate and act of criminal conspiracy. But this is basically where FIR is that some alleged false certificate was issued by Mr. Sri Yura Tagan. Now, I will read just now. It is to inform that intimate your good office that in some years ago, namely Hayang Mangfi, presently MLA of 9 Changdajo ST Assembly, then proprietor of name in style of MSHM Traders, has taken multi-crores of rupees on loan from Itanagar Cooperative Apex Bank Limited, through case credit overdraft and IDB. And very surprisingly, the administrator of bank has sanctioned crores of loan without securing any mortgage as security equivalent or part to the said loan, and without considering the financial position capacity of Sri Hayang Mangfi in order to secure the public deposit, so and so. That, sir, after default in payment of monthly loan, Sri Hayang Mangfi in the year 2000, a total amount of 19 crore 50 lakhs something so and so, and rupees 9 crore 55 lakh 20,000 respectively has been stand due. As such, bank has filed a claim before Lok Adalat at UPA, but illogically Sri Yura Tagang, my lord. Now, allegation is against Yura Tagang, my lord. Then manager has waived off more than 12 crores of loan by abusing his power and position. And accordingly, on dated Honorable Lok Adalat at UPI settled and declared the matter in case of so and so, with due consent of the bank manager Sri Yura Tagang as plea before the court for an amount of rupees 10 crore, and ordered that the settled amount shall be paid in 6 equal installment so and so on dated indicated below, first installment and so, second installment, third installment, fourth installment, so and so. There are 3. That's sir, in another case being so and so, it has declared an award or settled rupees 6 crore 88 lakhs 39 lakhs, and ordered that the settled amount shall be paid in 6 equal installments so and so. 1 crore 14 lakhs 4 as indicated below, first installment so and so. That's sir, immediate after passing of the aforesaid degree and order within 3 days, and also without payment of single installment of the sole loan amount, as undertaken accordance with the decree, and even after tunes of amount of rupees 12 crore, public deposited money has been irrationally waived off or relinquished by Sri Yura Tagang, then the bank manager. Moreover, most surprisingly, on so and so, Yura Tagang has illogically issued self-manufactured and false no due certificate in favor of Sri Hayang Mangfi without appreciate even basic academic meaning of no due, by abusing his power and position. And further, it is pertinent to mention here that after taking advantage of such false certificate, Sri Hayang Mangfi has contested in State Assembly election 2019 and won. Hence, the same is amount to gross misconduct being a public servant. That, sir, having learned of the issue of such certificate dated so and so as well, the administrator State Chairman for seeking a proper elucidation of issue of such false certificate, and accordingly concerned authority has replied me through their legal counsel when it is stated that with respect to the issuance of an inadvertent and unauthorized no objection certificate by the then branch manager Itanagar Branch Apex Bank, after reviewing the information provided, it is evident that the branch manager issued NOC without proper authorization. This act was unintentional and unknowing, resulting from an error and act of ignorance. It is important to note that here the NOC issued by the branch manager being unauthorized and issued in error holds no legal weight. Therefore, it is clearly evident from the self-defense of Yura Tagang Bank has issued false certificate in favor of Sri Hayang Mangfi without authorization by abusing his power.
Long FIR.
My lord.
It's very long FIR.
My lord, very long affair, my lord. Thereafter, my lord.
Where is the allegation against you?
No, nothing, my lord. That's why I'm saying, my lord. My lord, basically, my lord, entire affair I will.
This is against the
Yura
bank
Tagang.
manager and
Hayang Mangfi.
Hayang Mangfi.
My lord, behind the scene is what, my lord? Basically, my lord, this matter I have already settled. This amount, my lord,
Just so in the FIR, you have not been implicated.
Yes, my lord.
There's nothing.
Nothing.
So the case investigated into.
Yes, my lord.
Charge is filed.
No. This is still, my lord, no charge filed.
Okay, then why you have filed this?
My lord, why? That's why police, what the investigation agency did is that on the basis of this FIR, I have been made one of the accused and wrote a letter seeking prosecution sanction in this case. I will, my lord.
Okay, then this petition is for
Passing my name only from this case.
the prosecution sanction is sourced from.
My lord, may I take to the my lord? Prosecution sanction, my lord will find.
Your prayer is again. Your prayer is in this petition,
For my lord, passing this case against me because nothing is there.
including the procedure, including the prosecution sanction sought for.
Prosecution sanction, my lord, once the case is there, out, my lord, I am not concerned about the prosecution sanction, my lord. Because basically, the police cannot register this case and I cannot be made as one of the accused in this case.
No, this is still under investigation. You said.
That's why, my lord. To investigate, my lord, something has to be there.
Yeah.
It is not something, my lord.
If there is nothing, then no charge will be filed against you.
Law says, my lord,
Hmm.
this is the now on what basis?
Now it is only at the stage of investigation. Now
Yes, my lord, last occasion also,
Hmm.
when the FIR was second FIR was filed,
Hmm.
alleging me 5 crore.
Hmm.
This court, my lord, that was also in the stage of investigation only. It's my cases like this, my lord.
See, if there is nothing against you, why should you worry?
No, my lord, now they are going to, my lord, kindly turn to page number 94.
Are they disturbing you?
Yes, my lord, calling me to come in with, my lord, kindly page 94, my lord. That's why, my lord, otherwise, my lord, had they not kindly turn to page 94, my lord, annexation 10, 94.
Four. Yes.
My lord, type copy, where my lord will find it 95, my lord.
Hmm.
This is, my lord, forwarding prayer for prosecution sanction in respect of Sri Olik Taring so and so and so and so, SIC 13 of so and so. I am directed to forward the draft charge sheet, draft prosecution sanction format and other related documents as received from the so and so. It is prayed that the prosecution sanction against Sri Olik Taring so and so may be accorded. Meaning thereby, my lord, in the charge sheet, I have already been made as accused. So before submitting charge sheet,
You are for?
I am for Dr. Olik Taring, my lord.
Okay. Yes, ma'am.
My lord, my case is like this, my lord.
Mhm.
This FIR, my lord, has seen this. Now I have laid out.
Okay. You were at that time
I was the administrator. This
administrator.
19 crore was sanctioned during my tenure.
Okay.
And my lord, being an administrator, my job was to sanction the loan, my lord. Bank, my lord, what is the function of the bank? It's to loan amount only, my lord. And now this, and for and entire overall, my lord, 71 crore rupees was sanctioned during my tenure as the administrator. First charge sheet, first case, my lord, FIR, altogether this 71 crore is included here. Now, thereafter, my lord, the second FIR was filed, which was set aside.
Just a minute. The trial court record we have received.
Yes.
Have you gone through otherwise?
No, my lord.
You go through first. You go through, assist the court. If there is anything against
My
the
lord, in my humble understanding,
Hmm.
my lord, the charge sheet was filed.
Hmm.
There was a case, my lord, in 2016, my lord.
Hmm?
In 2016, my lord, an FIR was filed. Investigation was done. Charge sheet was filed.
in this case,
Yes, regarding to the misappropriation of 71 crore.
700 crore. And then this is then
There,
part of
yes, thereafter, my lord,
Hmm.
again another FIR was filed
Hmm.
in
for 5 crore.
2018, my lord.
Hmm.
Yes. Again, the petitioner came before the honorable court, and the honorable court amalgamated those two cases, my lord,
Mhm.
stating that since it is a part of that 71 crore,
Hmm.
there cannot be a second FIR.
Mhm.
Now again, there is a third FIR, my lord,
Hmm.
and this is pertaining to 19 crores, and this is also a part of the 21 crore.
71.
Sorry, 71 crore.
Mhm.
Therefore, my lord, in my humble understanding, my lord,
Mhm.
I concede to my friend.
Okay.
It is a part of it, my lord. It is on record, my lord. I've
Okay.
got the instruction, my lord.
The rule pass as necessary order then in that case.
Therefore, my lord, in my humble prayer, my lord, what I would say is, my lord, like the 2018 case, my lord, this case can also be amalgamated into the 2016 case, my lord.
Yes.
So that, my lord,
Where is that order, by the way?
My lord, kindly turn to page number 63, my lord. Page number 63, my lord.
Okay.
My lord will find, my lord, here all these judgment, my lord, T.T. Anthony and Arnab Goswami, all these cases have been relied, my lord. Why second FIR is impermissible, my lord? Cannot be, my lord. Then,
If
my
it is
lord,
a-
operative portion, my lord, may I take to page number 67, bottom, my lord. At the bottom, last paragraph, my lord.
Mhm.
In view of the settled position of law by the Honorable Supreme Court, as well
Mhm.
as the written instruction that are
Mhm.
placed on record by so and so learned, the present petition is allowed, directing that both the FIR be amalgamated into one case, followed by the investigation. It is made clear that the second FIR, based on the same set of allegation, is declared to be invalid, and consequently, the registration of the second FIR would not be taken into account any further. So, this is the, my lord. Now, my lord, when 5 crore was already, my lord, set aside, saying that this is a part of the 71 crore.
Mhm.
Now, on 19 crore, how, my lord, another third FIR, my lord, is permissible?
We have another other advocate also. We'll have him also some hearing.
Yes, my lord.
Okay, we'll
It's
take up
for
of
the informing.
informant.
Yes.
Okay, that is, we'll just
Yes.
have him hearing for some time. So we'll take a break of
Right.
4 minutes.
My
Okay.
lord.
Yes.
My lord, I think I am clear, my lord.
Hmm.
So far, my lord has seen this order in the similar circumstances also, this order has been passed.
Yes.
Two-way, my lord, ground, my lord. First, FIR, there is nothing, my lord. Second, my lord, even conceding, my lord, even if something is there, but this bar will come because
No,
second,
this earlier, second FIR was amalgamated
yes, my lord.
to,
First,
where is that or in view of settle?
my lord, kindly turn to page number
63.
67, my lord.
Mhm.
At the bottom, my lord.
Yes, is allowed to the both FIR. So in that case, now charge sheet already filed?
Yes, my lord.
Now how do we, this?
No, because now here there are two more persons have been implicated, my lord. Why I'm praying for that, my lord? That's because, my lord, at least the investigation will have the liberty to file supplementary charge sheet, my lord.
Okay, in that case.
Yes, yes.
Okay, so these,
Because only
the
with this,
material contained in this
yes, my lord.
case would be filed in that case as a supplementary charge sheet.
Yes, my lord.
Whether the IO has made a prayer for keep it open to file supplementary charge sheet. And,
That can be prayed at any stage, my
That
lord.
is there.
no,
It's no bar, my lord. Further investigation, my lord.
no, unless we keep it open.
No, my lord. Law is very clear, my lord. At any time, my lord, you can pray, my lord. And with the prayer, with the leave, my lord, that there is with the leave you can file, my lord.
172.8,
170,
probably.
178 earlier.
73.8.
Yes, my lord. Within-
And then now I think would be BNSS would be,
Not aware, my lord.
So, in this case, my lord,
because unless.
otherwise, my lord, in this case, 71 crore already charge sheeted, my lord.
Mhm.
Meaning thereby 19 crore has already been investigated. My lord.
Yes, yes.
That's why, my lord, there is no requirement of even filing further,
So when the second FIR was directed for amalgamation, at that time also
charge
the,
sheet was not filed.
not yet filed.
Yes.
So, but then it was amalgamated.
My lord, my learned counsel is having some technical problem.
Hmm?
Not getting audio.
Not getting audio,
Yes, sir.
it is his problem. Our side is okay.
Otherwise,
That's
also,
why,
he-
matter may be fixed on Wednesday.
No, just a minute. We are coming on to, the end of, I think, the discussion, just 180, so 190, 173, 2. 173.8, probably. I think this shall be deemed to be preclude from further investigation in respect of an offense after a report, so and so, has been forwarded to the magistrate. And upon the investigation of the charge of. Can submit further report, huh?
Look, this is always open. Only the requirement is, my lord, this matter has been on many judgment, this has been discussed. Only, my lord, there is also, there is no mandate that you need the permission, but as a, my lord, judgment law, my lord, this has been, then generally it is preferred, my lord. And there is no absolute bar, or it is not something if permission is not sought, if I.
So we'll make it clear, supposing just subject to, of course, the Learning Council for the informant. So have to make clear that liberty granting to the investigating agency
My lord.
to file supplementary charge sheet if there is any.
My lord.
in this.
Yes,
Okay.
my lord. Yes, my lord.
Yes, Mr. Secretary, can you hear us? No, I think he's. Hello. You just call him in telephone, through telephone.
My lord, last occasion submission was recorded, the counsel for the informant submission was recorded in the last order, my lord. Well, my lord, it is reflected that, my lord, he has considered very candidly, honestly, my lord, that in the FIR there is no allegation against the, that is been recorded in
You are not audible.
last order.
Last order.
Yeah, you say, right. Yeah.
Para. Last order 29-7.
Yes, 29/7 will be law.
Which para? Secretary Learning Council for the Informant Submit, sir. The allegations are not primarily against the petitioner, but are mainly against the loanee and the bank manager. So he had already submitted earlier.
My lord, that recorded.
The Learning Council appearing
Yes,
on
yes.
behalf of the.
That is only on records, my lord.
Oh. No, you are assisting Mr. Sekhar.
I'm respondent number 2. He's applying for.
Assisting, you are assisting him. So just, need to just inform him that we will dispose of with this direction. Can you hear us? No. Just call him once and inform that going to dispose of.
Not getting any.
Not getting the phone also. It's 193 in the BNSS.
193,
93.
9. Now it is, my lord, this BNSS, this has been, proviso has been given that further investigation with due permission of the court. Earlier, this was not. Earlier, that was the.
Bola. In the present case, also probably the investigation almost completed.
Yes.
Only need to submit
Yes.
charge sheet. But then this submission, this charge sheet would be the supplementary charge sheet
My lord.
to that. Okay. Where is?
Can we fix the matter on Wednesday?
Wednesday?
Yes. My
It's not getting. So then, okay, just, we have heard you both, but then we'll have just is consent also. Okay, we'll just get it listed on Wednesday to dispose of.
My lord.
Okay.
Right.
Mr. Rajesh, Sona, Senate Counsel for the petitioner. Also had Mr. Opada, Lion Special Public Prosecutor for the ACB, Arunachal Pradesh and Arunachal Pradesh staff. However, Mr. R. Shekhar, who is appearing through video conference due to some technical glitch, his voice could not be heard. Staff. In view of the above, let this matter be listed again on Wednesday. Okay,
26.
26. He says that on Wednesday. Okay, then no problem.
It's
Okay.
part had matter.
Automatically it will dispose of on Wednesday. Okay. No need to mention part hard.
Well,
My lord, will be requiring the CD, my lord.
The CD, let us keep it for the time being. Or what? Oh, no, just on that day you bring it.
Okay, ma'am.
Just see it, and if it can be some, come in into some help.
My lord.
Okay, you just go through it once, if there is any.
That's why, my lord, I have submitted that, my lord. There is a recent instruction, my lord. It will clearly during the investigation.
Instruction is also there.
Yes, my lord.
Just a minute, huh?
I flagged it, my lord, the yellow one, my lord.
Okay.
Yes, my lord. Para 5, my lord.
If the documents and all the documents recovered and seized in that case is similar to this, no need to even file supplementary charge sheet also.
But then, my lord,
But then it has to be, of course.
yes, my lord.
Okay, you want that this should
Yes.
also be amalgamated.
Yes, my lord.
Okay, no problem.
That liberty will.
It's clear otherwise. So only just on that day, we'll just have him hearing. Okay, on Wednesday, huh?
Item number 10.
Yes, 10.
Yes. Hello, this is a,
What remains here?
it is the mayor's opinion,
Mr. Sanoa,
yes,
so what remains here? Interim vacated,
vacated, man.
what remains then?
My lord, this appeal may be heard and disposed of today. The main appeal.
Mhm.
Interim,
But then
interim
you
was,
said that execution petition filed,
yeah, it is filed there.
execution petition proceeded.
No,
What further action has been taken?
they have not yet summoned us again. They have not yet summoned us again. That is pending there. Now, my lord, this appeal which I have come before this honorable court is against the judgment order dated 18/12/2025 of the learned civil judge. The learned civil judge disposed of the appeal, first appeal, on the ground that it doesn't have jurisdiction. It didn't dispose it of on merit.
Let us see the
Yes.
impugned order.
The impugned order is page number 60. 96 is operative,
Just a minute, huh?
109 is the operative part.
Just a minute, huh? Who filed a complaint before the customary court?
The respondent here.
Recovery of 9 lakhs.
Yes, ma'am.
And the customary court decreed
Yes.
directing the applicant to pay this amount
Yes, including
along with
some
the interest.
including interest,
So
So
totally
it-
it comes 15 lakhs.
15 lakhs. Well, the facts are very different. The customary court failed to see that I was not the person who took the amount. I have not gained anything from the respondent. I merely introduced him with one third person, Mr. Jeviso, who took the petrol from the from this respondent. And the respondent claims the amount from me because I introduced him. I don't have any liability against. But the customary court failed to see that and failed to even summon the third person also. The person actually took the fuel. Those are my grievances. So I approached before the civil court, but the civil court turned me away saying that I cannot directly approach civil courts from customary courts. I have to go.
It was a customary court, not the inter-village.
Not
It's a
interview.
customary court.
Yes.
Okay.
The first village authority.
So what was the direction by the appellate, first appellate court?
The direction given by the
Approach to whom? Is there any direction?
intervillage.
Inter-village customary.
Yes.
Okay.
He has directed me to approach appropriate forum he has meant.
So what is your submission on that?
My submission is, my lord, he has relied upon section 15 subsection 4.
Yes.
And he says that this directs us to go to intervillage. My humble submission is that, my lord, before the section subsection 4 was inserted, it was inserted by the amendment of AFR Amendment Act of 23. Before this was inserted, subsection 15, section 15, subsection 3 of APCC Act gave us the power to the right to approach civil courts from village authority or inter-village authority or whichever name code. That power is still existing. Subsection 4 did not delete that. Section 15, subsection 3, the proviso still says that. Well, if you come from 2021 Act, then it would be more properly understood.
21.
Yes, from 21. 21, in the 21 Act, this section was customary
15.
courts appeals were introduced, my lord.
15.3.
15.3. In 21 Act 15.3, it reads second proviso gives us the power.
Provided further.
Provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge.
Yes,
as
in
the-
case an appeal is preferred
Yes, preferred.
against, okay, judgment of the customary court
Yes, again, or
in the court of district judge or in the court of additional reference.
yes.
That's the case maybe. The court of district judge or the court of- In this case, you appeal before the civil judge.
Yes. Earlier, this introduced us, this gave us the right to approach civil.
They had two choice, one to dispose of or to trial de novo.
Yes.
So
The idea here is that Civil judges will look after appeals from customary courts henceforth, or try the case de novo. But some difficulties arose because there are so many districts, far-flung districts, which do not have district judges or additional district judges.
Here the civil judge is not mentioned.
Yes, yes. This is the first 21. This was introduced through which we used to approach civil judges. Civil judges means district judges at that time. So,
But then,
difficult
as per the pecuniary jurisdiction, the district judge will endorse it to the civil judge.
yes, yes, that was there.
Does that mean?
Yes, it could have been said like that. But so difficulty arose, Your Honor. There are so many districts which have civil judges, but
Yes.
there are no district judges. So,
But then it has to be, then in that case, it has to be filed before the divisional. But then say the divisional session court, division,
uh,
the in charge of the district court having jurisdiction in that district, covering 2-3 district.
yes, yes,
So then in that case, if it is the jurisdiction, as per the pecuniary jurisdiction, it will endorse to the civil judge.
civil, it could be, yes.
It is understood.
It is understood like that. But anyway, due to this, I believe due to this difficulty, they
So
amended
this,
this section.
and then in your case, when it was,
Your Honor,
impugn order was passed,
25.
2025,
Yes.
after implementation of,
After implementation of this and then after amendment also,
after amendment,
Yes, yes.
23.
23 amendment.
So that is 15-4.
Yes. Your Honor, before going there, Your Honor, kindly come to this amendment of 22.
Just a minute. Hmm?
22.
22 amendment.
Yes, amendment, which introduced this, which deleted the second proviso.
Just a minute, huh? Twenty-two.
Second proviso, this second proviso was deleted, and then this addition was made. These entries were replaced the second proviso.
Second proviso deleted.
Yes, and these are inserted, which reads, my lord,
Just a minute.
provided further that.
Just a minute, huh?
Yes.
In the
22 amendment, Article 3.
22.
Yes.
3.
Yes.
What to do? Proviso. 3. Subsection 3 of section 15 after the rules. Photo. In the principle. Subsection, kindly read 1 that
Yes.
in the Principal Act.
In the Principal Act, in subsection 3 of section 15, after the words Court of Civil Judges of the district appearing in the last part of the sentence, the courts and the case, and in the case the Court of Civil Judges Senior Division has not been established in the district, to the Court of Additional District Judge or the District Judge as the case may be, shall be added. So this gave parallel powers to district judge and then civil judge together. As it made the civil judge senior division or junior division or district judge or additional district judge.
Yes, the case may be.
Yeah, as the case may be, as the first appellate court, as the first civil court to take up decisions, appeals from customary courts. So
Now it can be filed before the civil judge also.
yes, civil judge and district judge, whichever the case.
Mm-hmm.
Now it can be filed, and then second appeal lies before High Court, dishonorable High Court.
And the second proviso. And what more?
And sub-article 2 in the second proviso of subsection 3, which of section 15, for the existing entries, the following shall be substituted. Earlier, this second proviso gave us the power to go to district courts. So this was deleted because now civil court has been introduced.
This provided further that from the date of this has been deleted.
Yes, yes. So this was brought. May I read?
Yes.
This reads, provided further that in case the deputy commissioners could not dispose of the pending appeals in their courts within 1 year from the date of commencement of the Arunachal Pradesh Civil Codes Act 2021, they shall transfer such pending appeal cases to the courts of civil judge, the courts of civil judge in division, the courts of additional district judge, or the courts of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. Then, provided also that in case an appeal is transferred by the deputy commissioner or preferred against the judgment of the customary courts in the courts of civil judge, the courts of civil judge senior division, the courts of additional district judge, or the courts of district judge, as the case may be, such appeals shall not be set aside merely on technical ground or procedural lapses, but in the interest of justice shall be disposed of as may be deemed appropriate or proceed with the case de novo. This was introduced. So it says transferred.
So it says that such appeal shall not be set aside.
Yes.
Merely on technical ground.
Yes, that is there.
Or procedural lapses.
Yes.
But in the interest of justice shall be disposed of. The case may be deemed appropriate. Or proceed with the case de novo. So the civil judge, although according to you, had a power under this proviso, but then return it.
Yes. Because of this, another addition which was made in the same amendment, the subsection 4 was introduced. The same amendment.
If agreed to by the parties.
Yes.
Yeah, let us read.
Yes, it says an appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or apex customary court.
If agreed.
Yes, if agreed. And later it was again amended.
Aggrieved.
Yeah.
Say aggrieved.
It says if agreed to by the parties. Now it is as amended by the 23 Act, Amendment Act, AFR Amendment Act. 23 Amendment Act is there.
Or if aggrieved.
If the aggrieved party desires has been added. Earlier it stood only as if agreed
the
to by the
agreed
party.
also still remains.
Yes, that also remains.
Aggrieved. Or added that if aggrieved.
Agreed party
aggrieved parties
desires has been.
So this inclusion is aggrieved party desire.
Desires. It's an option.
So
the plain reading.
Not a compulsory, not a mandatory.
Yes, yes. If the aggrieved party desires, if agreed to by the parties, or if the aggrieved party desires. This is a conditional sentence. It cannot be read as a compulsory rule.
So now let us see the impugn order.
Impugn order, page number 109.
Where is it?
109, paragraph 44.
Yes.
In third proviso of section 53, it is provided that civil court shall not set aside the appeal, so file so and so. So one can argue that the nature of objection.
It is 15. Okay, 3.
Yeah.
Yes, it is provided. That the civil court shall let us read it.
Yeah. Court shall not set aside the appeal, so filed merely on technical grounds or procedural lapses, but in the interest of justice shall dispose of the same as may be deemed appropriate or proceed with the case de novo. So one can argue that the nature of objection raised by the respondents in this case being technical, the civil courts can address the appeal. If such argument is accepted, then more legal complications will rise arise in future. For instance, the in third provision of section 15(3) of APC Act 2021, it provides the Court of Civil Judge, Junior Divisions, Civil Judge, Senior Division, Additional District Judge or District Judge shall not set aside the oh, 109, one thing. What is?
Is it
Yes. So
64? Is it 65?
I think this page,
Shall not set aside.
yes,
It's not a continuation. I think one line,
page 55.
senior division, additional district judge shall not set
Some
aside.
problem is.
Hmm? Is it the continuation? I think
44.
para, it's a 44.
Yeah, 44. And 45 it says. It should be, I don't know what happened. This. Now the part is missing.
Hmm.
Whether in the LCR there is LCR is it? नहीं क्या?
Additional district judge shall not set aside the, no, it's, I think, it's all the same.
Same.
Say not set aside the of pecuniary. It does it's not linking. It doesn't seems to be the continuation of this last line. And page 64.
Anyway, my lord, this conclusion is that further this court has already held.
Case cannot reject the technical ground. Further, this court has already held in the foregoing paragraph. The civil court does not have the jurisdiction to take up appeal against a decision of the village authority due to various reasons. When civil court is not the appellate authority for the decision of the village authority, the appeal cannot be addressed. Whether it may be on technical ground or on merit, hence this unable to agree with such. In view of the discussion, come, let's read the order then.
Yes. In view of the discussions made in the foregone paragraphs, the issue is decided in negative, and it is held that all the appeals are not maintainable. Accordingly, they are dismissed with liberty to file appeal before the appropriate forum. So, hence I approach this honorable court.
What is in between here? This page 44 and
As per verbal as far as I remember, he meant argue that this is his case. What else? As per the verbal discussion which we had before the court, he said that the customary courts will be totally bypassed. Inter-village customary courts will be totally bypassed.
shall not set aside the. I think one page is missing.
Yes.
Where the learned trial, sorry, the lower appellate court has made an observation that it cannot be taken up by this court unless the appellate approach the inter-village territorial
The 43, paragraph 43, my lord.
43.
Yes.
Yes.
Yes, paragraph 43, there may be an interpretation that the provision of appeal in the first provision 15.4 is only for those appeal which have been filed before inter-village territory customary court or apex customary court, not for the appeal from village authority, because the provision of appeal already exists in sub 15.3 for the appeal against the village authority, customary courts to civil court. However, this court is inclined to differ with possible interpretation because the scales of arguments is presented by the learned counsel for the respondent and findings of this court as discussed in foregoing paragraphs are tipped in favor of the respondent side, but those are not reiterated here to avoid repetition. Further, word shall is used in section 15.4, which signify a command that must be performed, thereby mandating that appeal from village authority will lie before the inter-village territorial customary court or apex customary court. If the legislature intended to make inter-village territorial customary court or apex customary court as optional appellate court, the word may should have been used. This is the logic. This is the argument.
Inter-village territorial customary court or apex appellate court. The word may should have been. So. Okay, you shall lie
Yes.
before the court of civil judge. General division. The court of civil judge. But here also, thereafter only it is provided further that it shall not set aside, isn't it? Although in the proviso, it is issue, it say that the customary court shall lie before the court of civil judge, senior division, junior division as the case may be. But then provided further, it says that it shall lie, it shall not set aside an appeal.
Yes.
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 What do you say?
Rebuttal. So this appeal is completely on misconcept of the law.
Okay.
Well, my rebuttals would be on three poles. My objection. So first would be, there is no decree. Or since this is the second appeal, which has been filed under section 100, order 42 of the CPC. This is an RSA. So, this is an appeal from the decree of an appellate court. So there has to be a decree first. To file an appeal, there has to be decree. As defined under section 2, subclause 2 of the CPC. And decree is, it defines that the formal adjudication of the rights of the litigants. But in this case, the impugned judgment has not decided the merit of the case. It is only when to say that the appeal is not maintainable.
So should have come under revision.
Revision. Because and accordingly, since no decree has been drawn by the court below, so appeals shall not lie. It should have been filed by way of revision.
Revision.
That
The
is
proper way would have been.
contention. Second, in this Secondly, my lord, this impugned judgment, my lord, it is a common judgment, my lord, wherein, my lord, 50 different civil appeals, it were taken up together, my lord. Wherein, my lord, 50 different civil appeals.
Okay, this is common.
Common, my lord. A common judgment and order was passed, my lord.
Okay.
So, out of that, my lord, this appellant hearing, he was the appellant in civil appeal number 47 of 2025, my lord. So, my lord, my contention is when a common judgment and order has been passed, one of the aggrieved litigant or the appellant cannot challenge the whole judgment, my lord.
No, in respect to him only,
But my
are you challenging the entire judgment?
entire judgment, my lord.
This, the entire judgment, the mandate that we cannot approach the civil court from inter-village, from village authority directly. This part I'm challenging.
No,
So it has to be like the entire judgment only.
Okay.
my lord, my
Okay.
contention is, my lord, only one of the aggrieved cannot challenge the whole judgment on behalf of the other aggrieved person.
Unless authorized.
Because, my lord, my lord, appeal is a personal right, my lord, which has been accused to the aggrieved person, my lord. Because, my lord, in the prayer portion of the RSA, my lord will find that the appellant has challenged the whole judgment, my lord. Which is, my lord, not tenable in the eyes of law. He ought to have, my lord, sought for the separate remedies, my lord, only in pertain with his own. And, my lord, the last ground is, my lord, the contention, my lord, which has been labored in this appeal, my lord. My lord, the basic issue is that, my lord, whether any order, my lord, being passed by a customary court, it is, my lord, appealable before the inter-village customary court, or, my lord, it is appealable before the civil courts, my lord. So, my lord, this A for, my lord, section 5, my lord. A for, my lord, section 5 has prescribed the mechanism for the establishment and the, my lord, procedure to be adopted by the customary court, my lord. And, my lord, AP Civil Courts Act, my lord, it has prescribed the mechanism for an appeal to be filed before the civil court, my lord, from the customary court. So, my lord, in these two acts, my lord, it has defined the customary courts, my lord, in a plural terms, my lord. It is, my lord, firstly, a customary court, which, my lord, village council. Secondly, my lord, inter-village customary court. And thirdly, my lord, it is the apex customary court, my lord. So therefore, my lord, this act has been amended in the year 2022 as well as in the year 2024, my lord. So, my lord, amendment made in the 2023, my lord, has made it explicitly, my lord, clear that any appeal from the customary court shall lie before the inter-village or the apex customary court, my lord. My lord, may kindly see this amendment of 2022, my lord.
Where a substantial question of law has been
Not yet framed, my lord.
issue framed.
Not yet framed.
Not yet framed.
Not yet framed by this court, my lord.
Okay. Where is the substantial question of law?
Why, which I have suggested, my lord, is, it starts from page number 11 of my,
11.
yes.
How many?
My lord, I'm suggesting 14 total.
Oh. Let us see after Act 2. You just think he has raised the questions should have been under revision. There is no decree. I didn't see that. If there is no decree, think about it.
Yes, okay.
Item,
14 minutes. One.
okay. Service not
While-
complete.
Yes, service is not completed against the respondent number 2 minus private respondent.
Okay.
The matter is just the POCSO matter, my lord. Well,
Still awaited.
yes, my lord. So, my lord,
Okay.
I may allow to take fresh step, my lord,
Okay.
upon respondent number 2 minus.
Mr. In view of this note that the service is still awaited, Mr. N. Rama, Land Council for the petitioner, praise for allowing him to take fresh steps upon the respondent
My
number
lord,
2.
fix on 3 minus, 3 September.
Respondent number 3
No, my lord, respondent
or
number
respondent number 2, the prayer is allowed. The steps, the fresh steps upon respondent number 2 within 2 days, 3 days.
my lord, matter may fix on 3 minus, 3 September.
Okay. 3 days. Stop, list the matter again on 3rd.
Third minus.
3rd September.
Yes,
Okay.
my lord, I also beg to mention item number 19 minus.
19.
Yes, this also since the service is not completed over the respondent number 2 minus, private respondent.
You have not filed a compliance affidavit also in that case.
Yes, my lord.
Okay, Mr. N. Rama, Land Council for the petitioner, praise for further, how much?
My lord, list after 3 weeks, my lord.
To further 2 weeks time to file compliance affidavit. Stop, please pray for, list the matter after 3 weeks. Okay.
My lord, interim order may be continued.
The interim order passed earlier shall continue till the next date of listing. Okay.
Much okay.
My lord, I have to mention item number 20 and 21.
20 and
21.
21?
Yes.
Yes.
Urgency regarding the hearing of interim of provision.
Okay. So what do we do?
Let's fix for on Wednesday.
Wednesday?
Is the
What was this matter about?
It's a lane competition.
Hmm?
Lane appeal. LA appeal.
Okay, okay.
In last occasion, the government has taken the time for instruction.
Instruction here.
They come from.
Okay. Obtain instruction?
Yes.
Okay. So you bring it on record then by filing
On Wednesday, maybe.
on Wednesday. We'll fix it on Wednesday, but in the meantime, you bring in the instruction. Have you received the written instruction?
Yeah, the order we have received.
Okay, then bring it on record by filing additional affidavit, small. That will be better. Okay,
May-
add Mr.
may I
Pinek.
please, Your
Yes,
Your Lordship, here I'm for the private respondent, Your Lordship,
okay,
3 to 8, Your Lordship.
okay.
And in IA, Your Lordship, I have to file my reply, Your Lordship.
You have to file reply.
Yes,
also.
Your Lordship. Therefore,
In this case, there is no need for reply. Since they are the caveat in this case. And caveat has already disposed of.
They appeared.
Yes, they are there. So all the records are in the telephone.
So IA is for what?
I is for the interim.
interim, Your Lordship.
Interim.
Yes,
You want to file objection?
yes, Your Lordship.
Can be allowed then. You file within a week then,
Yes, Your Lordship.
So my lord, this is urgency, my lord.
there is
The
urgency.
amount has disbursed to them also.
No, because at the time of filing also, the amount was in the process of dispersing only,
No, already disbursed.
already dispersed.
Yes, Your Lordship.
Then,
Though there's no need of reply also, my lord, since they have enjoyed the amounts also. So only the needs, interim need is that some amount need to be preserved, my lord.
no, you said that the amount already dispersed, then what amount is to be preserved?
Some, they've said some reliefs. That's why we'll convince this court to.
No, when you say that amount already released, What is to be
when
stayed?
we have filed the appeal, they had not come with the instruction. And when the matter is about to hear on 3rd of this August, then they said the amount of this dispersed. So in the meantime, the court has direction direction given that the.
see, there, you have filed this for interim, and then they want to file objection, let them file, give 1 week. You are praying for Wednesday, oh no, when?
Yeah, Wednesday after tomorrow.
Next Monday?
Next Monday. Yeah.
Monday, election petition.
Day after tomorrow is evidence is there.
No, day after tomorrow, it will not be possible. Evidence in election petition, that takes a lot of time.
Then Friday.
Monday?
Monday, Your Lordship.
Monday, okay.
At least,
But till Friday, you should file, so that it
it
is
would be
listed
very
on Monday.
difficult for me, Your Lordship. It's a very voluminous IA, Your Lordship.
They've already.
Then you say there is no need to file, then don't file.
No, they are praying for freezing of our account, Your Lordship. That is the issue here.
Your account.
Yes, yes.
Once it was, you see, transferred, see, must have you, you used now, by now, must have withdrawn.
And that's what has happened, is they have,
How do we,
they have not
Then-
followed section 77 of subclause 2. When the matter referred from the.
but if you have a claim, that even if they have used also, that will survive. They are bound to pay back. But then, is normally it's when there is a case, you should not actually, so the amount, even if you spent also, that doesn't mean that they will not get. If they are entitled, even if you have used also,
Yes, yes.
so then caution your client. Tell them that since the case is there, so some amount has to be preserved.
That's a totally different issue, Your Lordship. At this
Yes.
stage,
So, but, okay,
Civic
let
time
them
may be
file.
Lordship
Okay.
at least.
Mr. T. Nega, Land Council for the applicant stuff. Mr.
he may enjoy, Your Lordship.
Sorry, Mr. Akud, sorry. Mr. Sorry, Riram, Akud and Riram. Mr. Riram, Land Council appearing on behalf of the respondent number. Some said he has received instruction and prays for some time to bring the same on record by way of filing additional affidavit. Mr.
He may enjoy.
Also, he Major, Land Council appearing on behalf of
3
respondent
to
number
8.
Hmm?
3 to 8.
3 to 8.
Yes.
Some is that they wants to file objection. Stop. A week time is granted to Mr. Major to file objection. Stop. Mr. Nega has shown some urgency in the matter. So in view of the above, list the matter again on Monday, next Monday.
No
Okay.
further examination.
Then
Highly obliged.
we will have to pass on that day. Okay.
That is much.
But
12 months.
Item 12.
May pay for this one, Wednesday, day after tomorrow.
Well, Rajesh, Wednesday would be difficult because Wednesday evidence is little difficult. We can fix, this is what?
Bail, my lord.
Bail Thursday, then?
Thursday.
Hmm.
Thursday, I'll be out of station. Then my lord, can it be on 31 Monday?
Okay. Monday is okay. Okay, Monday.
Much.
Mr. Rajesh, on a prayer of Mr. Rajesh, let this matter be listed again on Monday. Okay. So CD have you received?
TCR.
Yeah, TCR.
Yeah,
Okay.
already received.
Okay, then it's no problem.
Apply.
On the prayer of Mr. Raji had not been objected to by Mr. Etehlan Edison PP. Let this matter be listed on Monday. Okay.
Please, your lordship.
Yes.
Lordship, I would to mention for item number 13.
13.
It was fixed for hearing, but it has been come to learn that TCR have not yet come.
Not
So I pray.
Updated TCR.
Not received. Okay. No,
Office note doesn't show that.
is it TCR?
Data.
So, this is item, Mr. Patel.
And then it may be taken up my lord, later. Yeah. That would. Okay, then my lord, matter may be taken up my lord.
Okay.
Today itself, man.
Wait for some time then. Yes. Yes. Now, I think before admission, for admission, you have you said that 14 issues.
Yeah. Question.
Substantial question.
Yes.
Okay. So prior to that, because since he has raised a pertinent question, we need to have a hearing on probably the maintainability of this. Because he said that there is no decree.
Yes.
So whether this fulfills the decree or not, the order, impugn order.
Yes. My lord.
What is decree? CPC, let us see the definition 2. Section 2. Whether the present impugn order fulfilled.
My lord, It doesn't matter.
We,
This order, my lord, it is dismissed with liberty to file appeal before the appropriate forum. This is dismiss my appeal.
appropriate forum, what he meant
Yes. but-
is the inter-village territorial
Yes,
customary.
yes.
But then you have come in the second,
Yes, yes,
second appeal.
Yes.
Whether second appeal under 100 or 15 of the, this one, Arunachal Pradesh, whether it meant, it is mentionable. or
Section
not.
15 says that second appeal after the
Let us see that it doesn't fulfill otherwise, according to you.
this
It's not a decree.
it's not a decree exactly.
Okay. Then it will be, let us see, just,
The appellate court, the first appellate court has not drawn a decree. Has not drawn a decree. He has only given a judgment order.
then,
It is a judgment order.
means the formal expression of the adjudication. So there is no adjudication.
Yes.
So then probably second appeal,
Yes.
probably it will be a little difficult. You have to satisfy that.
As per section 100, subsection 4, my lord.
Mhm.
If I'm not wrong, my lord.
See,
In any case. Subsection 4, where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question.
But then since it is not a decree, it doesn't fulfill the definition itself. Thereafter, only because this is the root of the,
Then my lord may kindly exercise the inherent power.
the matter has been raised by him.
Then my lord may exercise the inherent power of this honorable court and convert this into an that also.
No, conversion, because they are converted into a revision.
Yes, revision. That can be.
There is not Malud.
So, no, probably it will be difficult. Because your second appeal, the way, the appeal
Yes.
memo prepared for the second appeal itself is altogether different.
My lord,
We will, if that be so, if you want,
Yes.
we will give a liberty, then in that case. Otherwise, you have to satisfy the court that it lies.
my lord, my right to appeal was denied by the first appellate court. That is that by this judgment.
That is why,
Yes.
by way of revision.
Yes.
So in the revision, we'll decide where to send it back. Well, can it be send it back to, probably there is some cases,
Yes.
this court decided, just send it back to decide. Either de novo or you decide it.
Yes.
So
Yes.
you need to find out. Some court, this court probably
Yes.
decided recently, not very, of course, long back,
Yes.
decided that is sent back. And that is also probably Pasigat.
I'm not aware of that.
If Malud, there's one Bomlu Basar case, Malud,
Mhm.
recently one.
You have to find out.
Yes.
So that is in probably revision.
Revision, Malud.
So I think you find out and then come back if you want. Or if you want, with liberty, we can allow you to come back with.
When Malud has held in that judgment, Malud, that
Hmm.
the appeal from the customer court shall lie absolute to the inter-village. That judgment has already settled the law, Malud. If Malud allows me,
That is in your favor.
yes, Malud.
Let us see just once.
Aware of the case.
But once it is filed before the civil judge senior division in appeal, but the present provision says that it has to decide. It has to decide,
Malud.
or de novo trial
Malud.
will proceed.
But Malud, this amendment of-
Cannot just set aside. Cannot just dismissed.
Malud.
Just no.
Malud, the
Which
operative
para?
portion is at para 21, 22, and 23, Malud. Malud, in this matter, the appellants has filed an appeal before the inter-village When agreed, the again appeal was filed before the civil court model. So it was challenged that the appeal cannot be, second appeal cannot be lied to the civil court model. But that was put in the.
Yes, second appeal doesn't lie
Yes,
there.
madam. Yes.
Because second appeal is always before the High Court.
Yes. Madam.
Second appeal, before the trial court, it is first appeal only.
Yes.
But then after appeal being filed
Madam.
before the inter-village territorial customary court, second appeal doesn't lie before the civil
Exactly,
court.
madam.
That was, of course, here in this case.
So, my lord, in this.
But then
Here
second
it was
appeal is
held
always
that, my
before
lord,
the High Court.
the appeal under the AFR model,
Mm.
it is different from the CPC model.
Right.
So the remedies there in the model, AFR, it has to be exhaust. So appeal has to be filed before the.
But here I think then in that case, this case probably is little different in the sense that the appeal itself was filed before the civil judge, because civil judge can entertain the appeal. It lies before the civil judge, but then civil judge says that because there is option, either you go to the inter-village or to the civil judge. So he has opted for the civil judge. Now civil judge, the option before the civil judge is to decide a case or to proceed for de novo trial. So that having not done, probably he is aggrieved. So I think revision lies, not the appeal, second appeal. It's not a decree. And then you may, you can come in the.
Your Malud may kindly see this para 23 Malud.
Yes. The provision, kindly, let us read.
Above provides inserted by the Arunachal Pradesh Civil Courts Amendment Act 2022 and further amended in 2023 specifically provides that first, an appeal from the village authority stroke customary court shall lie before the inter-village territorial customary court or apex customary court. It was held. Now it becomes mandate of the law, my lord. They are supposed to approach the inter-village.
Now appeal lies with, actually the appeal lies. But then this 15(4), the 23 amendment provides that aggrieved
or my yes, it Malud may kindly see this amendment.
Aggrieved party if deserves or prefer deserves can file before.
Malud, this 2022 amendment, Malud, it only said, Malud, if agreed to by the parties, Malud, parties to the litigation.
If the party agree, and there is also alternate.
And Malud, in 2023 amendment, Malud, it says, Malud, if agreed to by the party or the aggrieved party so desires.
Yes, yes.
So that part, Malud, makes it mandate to approach the inter-village court. Malud.
No, here also shall not set aside. It says, provided further that the court of civil judge, junior division, the court of civil judge, senior division, the court of additional division, as the case may be, shall not set aside an appeal so filed merely on the technical ground or procedural lapses, but in the interest of justice, shall, it also use shall dispose of the same as may be deemed appropriate or proceed with the case de novo. So that provision he has.
But Malud, my understanding is, Malud, on technical ground, Malud, the legislature had intended the misjoinder of party, the non-joiner of party. Those cannot be taken into a Malud as a technical ground. But Malud, the issue herein is that the forum of appeal, Malud. So Malud, this amendment of 2023, Malud, it has given a mandate, Malud, if the aggrieved party so desires, because Malud, the first part, if the parties agreed, Malud, the parties to the dispute, Malud, the winning parties shall never, Malud.
Now, just a minute, Mr. Sonowal. So what is the problem if you go for appeal before the?
My lord, it's a very expensive procedure.
The inter-village customer is more expensive.
Not at all. It is very expensive.
Is it?
Yes.
I think the intention of the legislature was that it's less expensive.
Yeah, no, my lord.
It's more expensive.
Practically, it is more expensive because I have to invite all my clan members.
Okay.
Almost.
This probably is a new.
because you're not in Kawang and all. Practically, it is seen. It is seen that usually, I'm not blaming. I'm not
right. No, I understand because it involves with a lot of people.
Majority somehow wins the cases.
Okay. So
usually.
It's more or less like the voting.
Yes, voting only. So we need people to speak on my behalf.
Oh,
as
you
much
have
as
to convince
possible.
each and every person.
Yes. So I have to invite, if possible, my whole clan members have to invite.
It's election then?
Yes, it's
No,
almost like
no,
election.
Ah,
So now in inter-village,
ah,
there is, in village authority, just one village, the members of one village decides the matter.
Hmm.
Some people of a village.
Hmm.
And then there is the Gamuda of the village. It's
Hmm.
less expensive. But when it comes to inter-village, I have
Okay.
to invite so many Gamudas from other villages also. And I have
Oh.
to ferry them also. I have to ferry them and I have to provide expenses for the vehicle, oil, fuel expenses.
And if you are not so popular person, then it becomes very difficult.
And nobody will come. I'll be standing alone and the other party will have so many people.
There is the hardship of the applicant.
Yeah, that
That
and
cannot be law.
I believe it is the intention of the legislation, my lord.
So you are in the advantage position.
And I believe, my lord, the legislation didn't intend that
Yes, yes.
to make me, to
Yes,
force
yes.
me to approach this inter-village customary court.
Okay.
Because when we read it very plain, it is very clear. It has created an option. It has created an option if the party desires or if the aggrieved party desires or if the parties agree, they can go to customary court.
Okay, I think,
Civil court.
so what do you say? Because you have two options, either to hear this
Yes, yes. My lord, then
on the preliminary question raised by him, or
My lord,
to withdraw and file revision.
in the definition of decree, my lord,
Hmm.
I try to convince my lord.
Depending upon.
the-
No, then in that case, we'll have hearing on maintainability. If you want to convince.
My lord, just a plain reading of the decree, my lord.
Hmm.
The decree means the formal expression of an adjudication which
Yes.
so far regards
Hmm.
the court expressing it conclusively determines the rights of the parties
Mhm.
with regard to all or any of the matters in controversy.
Mhm.
All or any of the matters, all or
Mhm.
any of the matters in controversy in the suit, and may be either preliminary or final.
Mhm.
It shall be deemed to include the rejection of a claim and the determination of any question within second, but also not include. So in fact,
You have to convince.
in order of dismissal for default of.
The learned civil judge,
Yes.
we must understand that give an option.
Yes.
You
Yes.
only says that you approach
Yes.
the right forum.
Yes. Yes.
That is what he said.
Yes.
It's not a decree.
And he says,
It did not affirm
Yes.
either
Yes.
the decision of the customary court. So that is why.
He dismissed my appeal.
Hmm.
Basically saying to approach.
Saying to approach only.
And
So-
section 5 of AFR says the government has to appoint. And AFR Act says government has to appoint or may frame rules. But customary court is not yet framed, not yet constituted as per section 5. So he's sending me to a phantom court now. No.
No, say there were 15.
The court doesn't exist in the village as per law, as per AFR.
But then in your district, it exists.
It is.
As per
There is an integral customary
section
court.
5 says, my lord, of
Mhm.
AFR says.
Mhm.
The deputy commissioner shall appoint such persons as he considers to be members of the village authority for such village or villages. He shall
Then
appoint.
again,
No such appointment has been done yet.
Malad, but can you see this page number 108 of the different judgment, Malad, wherein the parties and the council have admitted that there are 3 tiers of Malad,
No.
Kabang mechanism, Malad. 108, Malad.
he has raised a larger question.
There is.
That involves with again the interpretation of all those again. That whether can be the because as the case may be wherever it is available,
Yes.
it's understood. But then if you say so that it doesn't have,
Yeah.
or it doesn't
As per
exist,
section 5, there is.
it doesn't exist.
It doesn't-
Then in that case, the act itself
Hmm.
would be under challenge.
Yes.
Now, what do you want? Well, then
My lord,
Take-
if I'm
keep a
supposed
day
to-
for
if
day
I'm
for
supposed
hearing,
to-
day for hearing, because
if I'm supposed to convince regarding decree, my lord,
Hmm.
in my humble belief, my lord, I think it falls short of a decree. So with liberty, I'll file afresh as a revision, my lord.
Okay.
Better to just avoid this
Okay.
discussion regarding decree or not.
no objection. Okay. Then
There are law questions, no?
Mr. D. Sonwa, Land Council for the applicant, the petitioner. IA is filed by whom? IA also filed by you.
No, it's disposed of, your one.
Oh, IA already disposed of.
Yes.
Okay, okay.
वो grant किया था ना इसको.
Okay, Land Council for the appellant. Also had Mr. G. Riba,
Yes.
Land Council for the respondent. How many respondents?
One only.
Okay. Only one.
One.
Okay, sole respondent, staff. At this stage, Mr. Sonowal, Land Council for the appellant. Praise, praise for, praise that he may be permitted to withdraw this appeal with liberty to approach the file afresh under the appropriate provisions of law. Staff, Mr. Riba, Planning Council appearing on behalf of the sole respondent has no objection. Staff, upon consideration and hearing the parties, the prayer is allowed. This staff, according this appeal is dismissed on withdraw with liberty is prayed for. Okay. The interlocutor application, if any, also stands disposed of. Okay.
Item number 13.
May I please your worship?
Yes.
I'm appearing on behalf of the accused.
My lord, 351 corresponding to 313 also been done, my lord. And now is the stage of defense evidence, my lord.
Okay.
Now is the bars of completion only now.
What was the offense?
My POCSO, my lord.
Section.
Item number 16.
Yes. 16 is to be taken up first.
Yes, my lord, kindly go through the order of the 16, my lord. Page 20. In the
What
order
it
sheet,
to give?
order dated, my lord.
Not clear.
8, my lord. This honorable court was pleased to considering the recent Supreme Court judgment, this honorable court was pleased to grant me the interim protection and state the further proceeding of this court case, my lord.
Okay. Its investigation has been stayed. Further investigation.
Yes. So, my lord, we have taken steps also for this services
Just a
awaited.
minute, huh? Okay. Okay, just a minute, huh? What is the allegation? Let us just see once. What is the allegation? Land Senior Counsel?
Allegation that he has taken I have taken loan from him with an interest of 5%.
It's a loan case.
Loan case. Admittedly, it was a loan case. He himself admitted, informant, that he has given me a loan with 5% interest. In the page 20 in my criminal petition, Lordship will find the FIR. Basically, allegation that he has paid me an amount with a 5% interest.
What is the name of the accused?
Name of the accused, Deveswar Vadalas.
He is named accused in the FIR.
Yes, Lordship.
Okay. He was introduced by another person.
Yes,
Bhavesh Kachari.
Yes, he was introduced by another person.
Represents himself with the hiring information officers have in close connection with that.
In the page 21, my lord, the second
Just a
paragraph,
minute.
the subsequent.
Page
21, my lord.
Which one? Para? Just a minute.
Subsequently,
Just a minute.
start with subsequently.
Okay, yes, subsequently.
Deveswar Bora requested me to lend him a sum of
rupees. Okay.
3 crores only, assuring that the amount would be repaid within a 4 to 5 along with an interest of the 5%. So it is basically loan. That's all.
It's a loan only.
Loan. It is his case. It was a
Okay,
loan.
but they're not executed anything.
Loan, but I have failed to repay. Some amount has been paid, 10 lakhs I have repaid. That is his allegation, my lord. If it is a loan, my lord, admittedly with a 5% interest, there cannot be any criminal case. He can always go for a civil suit.
Whether pursuant to this or when you fail to pay, whether any notice was issued?
No, nothing.
Demanding
No,
repayment?
nothing. Simply on verbal, my lord.
No notice was
Everything
issued.
on verbal.
Then accepting money with the promise not returning, doesn't it make a criminal case? Cheating?
No, it can't be. Unless and until I have a intention to cheat from the very beginning. That's not there. Simple case of that I have failed to repay the amount. So basically, my lord, today I am not on the merit of this case, my lord, because the respondents are yet to appear.
Okay. So
my prayer is, my lord, in the bail application, there is stay, so the bail application lordship can dispose it off. And this matter can be fixed if for orders. Let the services be completed in the meantime. In the bail, I have already appeared, despite stay was granted.
okay, whether have you been formally arrested when you appeared? On your appearance, whether?
Yes, we have arrested and allowed to go bail, my lord. Page 32, my lord.
Okay.
My additional affidavit, my lord.
Okay.
in the page 32 in the my additional affidavit today, my lord. Page 31 is the challan. I have deposited the amount also. The page 32 is the bond.
Okay. This can be disposed of then in that case.
They have appeared.
He's cooperating probably.
He
Okay.
appeared, Lordship. But
Okay.
Lordship, in regarding the item number 16, Lordship, the service not been completed.
Okay, so let that be complete. Okay, hard, Mr.
Lordship, if bail is granted, then strict condition may be implied, Lordship, because Lordship, the investigation yet not been completed yet, Lordship.
No, investigation can't start now.
Okay, hard, Mr. A. Bora, Land
Investigation
Senior
will stay.
Counsel, assisted by Mr. Okay, Mr. Lawlin, huh? Land Counsel for the petition.
Lordship, I have a prayer, Lordship, regarding the item number 16. Yes, Lordship, the criminal petition, the stay may be Lordship revoked, Lordship, because as per the case study, Lordship, there is lot of
Just
material.
wait, then we'll dispose of this first. Thereafter, we'll come to section, okay? Also hard, Mr. El Hage, Land additional PP for the state staff, huh? Para. By in order dated 4/8/2026. While calling for the scanned copy of the case study, comma. This court granted interim protection to the accused. With the direction to appear, with the direction to appear before the IO of the case. And in the event of his arrest, comma, the accused shall be released on the interim anticipated bail on furnishing bail bond of rupees 50,000 with certain conditions. Start. Para. It is submitted that in compliance of the direction of this court, the applicant appears before the IO of the case. On,
Page
on which
31.
date you said?
Day before yesterday, my lord, page 31. Saturday, my
31. Okay, on 31/8/2026, before the IO of the case. Stop, huh? On his appearance, comma, the accused was examined and his statement recorded. Stop. No, on his appearance, comma, the accused was arrested in connection with the aforesaid PS case. Which PS case this is?
Doimuk, my lord.
Doimuk PS case. Doimuk PS case
75.
number 775/2026. And recorded his and he was examined recorded his statement, and after completion of all formalities, he was released on bail in terms of the interim bail order dated 4/8/2026. Stop. The Atlantic Council for the petitioner further submits that the accused is cooperating with the investigation of the case.
And he's a government
His
servant also.
father. Okay. Stop. Okay. And now, Mr. Learned Learned additional PP, while producing the case study, submits that the accused was arrested on 21/8/2026, and and subsequently he was released on bail in terms of this court's order dated 4/8/2026. Stop. See further submits that. See further submits that the accused is cooperating with the investigation of the case, and since he is cooperating and his statement has also been recorded, his further custodial interrogation / remand is no more required. Stop. Para. Add Learned Counsel for Senior Counsel for the petitioner as well as the Learned additional PP. Stop. Upon consideration, it appears consideration of the record, and also peruse the case study. Stop. Upon consideration, it appears that the accused has already been arrested in connection with the aforesaid police station case, and the accused is cooperating with the investigation, and as reflected in the case study, his further custodial interrogation / remand appears no longer required. Stop. In view of the above, the interim anticipatory bail granted to the accused on 4/8/2026 is made absolute with the same terms and condition. Stop. Where terms and condition with the subject to the following to the condition, subject to the following condition. Stop. That the accused shall continue cooperating with the investigation and appear before the investigating officer as and when called for. Stop. That he shall not hamper or tamper with the evidence of the case in any manner. That he shall not influence the witness or hamper or tamper with the evidence of the case in any manner. Stop. That he is from he stays in Arunachal.
No, my lord. He's in Assam.
Out of state.
Posted in Assam. He's
Okay.
posted in Assam.
Okay. Then he is out of the station only. We cannot say that he.
Lordship, but Lordship, this matter is very serious. Lordship. Allegation is serious, Lordship. Just because Lordship he's been interim protection is there, Lordship. He may be appear and cooperating with the investigation. Because Lordship.
Okay. He shall furnish his.
No, definitely will cooperate, my lord. After tomorrow,
He shall furnish his mobile number and inform the IO in the event of change of his address.
Lordship.
Okay, stop. He shall not leave the India without prior information to the IO of the case. Okay. With the above, this bail application stands disposal. Okay. Return the case study. Okay, then in that case, what is your submission?
Lordship, my submission that Lordship, in the criminal petition Lordship number 241, here Lordship, the interim may be vacated Lordship, otherwise the investigation cannot be done. As long as the interim is there.
His submission is that a criminal case, this civil case,
No, Lordship.
civil nature of case.
Lordship, I'm not pressing that much in the AB Lordship because he has already been protected Lordship. But the Lordship in the case study Lordship, the material is there Lordship.
So after hearing you only, it was when this order was passed.
Lordship, last
You have to file affidavit there in that case. One,
Lordship, may I Lordship the order dated Lordship on 12th.
you have to file interlocutory application for vacation.
Lordship, in the order dated Lordship 12/8 Lordship, the court has made the
let the
observation
other side
after
appeal
producing
also.
the case diary that the interim shall be further reconsidered on the next date Lordship on the basis of case diary.
Just a minute. Huh? You probably has not yet filed objection. You
Lordship,
file
we have-
objection.
Lordship, objection, Lordship, we have already case diary with us, Lordship. As per the case diary, Lordship, at least the,
Case there, this is case there.
yes, Lordship, this is the Lordship, status, Lordship, the,
Then
What it
my lord,
says.
the main,
my lord, just
Just a
before
minute.
my lord,
Just a minute, Lani Counsel. Lani Senior Counsel, just a minute. Huh? What it says.
Lordship.
This is case diary.
Yes, Lordship. Earlier, Lordship, I have submitted that they have appeared before the IO and his statement recorded. But the detailed Lordship is in the first case diary, Lordship.
This is detailed case diary.
Yes, Lordship.
What it says.
Lordship, there's lots of Lordship witnesses, their statement also been recorded and their statement is against this accused. And that Lordship, there are a lot of material Lordship against him. That's why Lordship investigation must be completed. Whereas Lordship, he has already been protected.
You bring this on record and file objection.
Lordship, already Lordship.
Bring this on record.
Yes, Lordship. Because Lordship, on the basis of this case study, I'll make my objection, Lordship. And then here, Lordship, respondent number 2 is already there, Lordship. The complainant.
Let the respondent number
Yes,
2
Lordship. Yes,
file
Lordship.
objection.
Yes, Lordship.
Okay. So on that day, we'll consider your case diary also.
Yes, Lordship.
We'll dispose of the entire matter itself. Okay.
Till then, Lordship, it is interim may vacated, Lordship.
But then once interim
once
granted,
granted, my lord, how
unless
without the application, they can, lordship, my lord, without the application, how the interim can be vacated. And if the
if he's
interim is
agreed,
vacated,
let
it
the
will be
respondent
jeopardized
file.
my,
Let the
yes.
respondent file interlocutory application for vacation.
Lordship, interim, they have already protected. They will no longer be Lordship in
See,
the.
after considering only, after considering the nature of allegation only, the court observed that it's a civil nature.
No, Lordship,
that is
no,
why.
Lordship. In the last occasion, Lordship, I have produced the case study on observation of that, Lordship.
That
they
is
have-
why you.
Yes, Lordship, they have,
fine.
Lordship, on the next day, the reconsider is order passed, Lordship, that after the perusal of the case study.
I'd like to hear personally also the hearing in the matter.
On the same ground.
Because it will need an
On the
hearing, my
same
lord.
ground, without any application, in absence of any application, it will be difficult.
Then, Lordship, next step may fix that, and next step that, respondent number 2 will appear, Lordship.
Okay. Mr.
Why she is so concerned about this
Assisted by
number
Mr.
2?
Lawrence, Lani Counsel for the petitioner staff. Also had Ms. L. Hage, Lani additional P, public prosecutor for the state respondent staff. The
Because service not been yet completed, sir. Service not been yet completed upon respondent number 2.
interesting is the petitioner has taken the notice upon the respondent number 2 is still awaited. In view of the above, let this matter be listed. When? Next week?
Sir, it's upon there to make the
No,
service complete,
they have
Lordship.
taken steps, but then
It's not been completed yet, Lordship.
petitioner has taken steps.
Yes.
So the notice upon respondent. And according.
We have taken
notice has
steps.
been- taken steps on 17/8 only.
The next week, Lordship, any date, Lordship.
Okay. Least a matter after a week. We'll say after a week.
In this,
Where is the address of the respondent number 2? Is it far away?
Yes, it is
It's UPI only.
UPI.
It was taken only 17. How long it takes? After a week, will it do? After a week,
Lordship.
okay.
Matter of lordship.
Deeply obliged.
You can take back the
Interim may
case diary,
continue.
no?
Interim may continue.
The interim order pass earlier shall continue till the
Interim
next
may
date of
continue.
listing. Okay. Okay. Yes, continued. Yes.
Obliged. Obliged.
Lordship. Item 17 is the election petition. Lordship.
Hmm?
17 is the election petition.
Okay.
Item 18.
17 and 17 is last.
No, Lordship, 18, 20, 20.
Hearing would be difficult. Hearing, if we take up the election, just a minute, just election. We'll finish up. Since we'll start with the election petition, if anyone for hearing, item 22, 23, what is this 18?
Lordship, I am appearing in item number 18 for the respondent number 2 and 3, Lordships. Fixed in the order.
Okay.
So, Lordship, I
What
may
is
be
this
allowed.
for?
This is for cancellation of bail. They have filed this IA for cancellation of bail granted to the private respondent number 2 and 3, Lordships. I am appearing and appearance for respondent number 2 and 3 in this matter, Lordship. I may be allowed 2 weeks time to file my wakalatnama and objection, Lordships.
Okay. Who is for the petitioner? Yes. In item 18, you are for the petitioner. Okay. Mr. None appears, item 18, none appears on behalf of the petitioner. Staffer. Mr.
K. Jain, Lordships. Kaushik Jain.
Land Council for
Respondent number 2
Land
and 3,
Council
Lordships.
would appear on behalf of the respondent number 2 and 3 and praised for 2 weeks time to file wakalatnama and to file wakalatnama as well as the objection.
Lordships.
The prayer having, you are for?
My lord, I'm appearing on for item number 21, my lord.
Item?
21, my lord.
Oh, no, just a minute. And the prayer is allowed, list the matter after 2 weeks. Okay.
Much obliged,
18 is after 2 weeks. Okay.
Much obliged.
Then item 21,
My lord, item 21, my lord, we had filed IA, my lord, which has been in fractures, my lord.
It has become infracture.
The order which we have challenged,
31.
it has been stayed, my lord, by the court below.
Okay.
So the matter, the IA has become infracture.
Okay. Miss Untijera, Land Council for the applicant. Submit. What about the CRP?
CRP, it's still pending. There is a
Okay.
stay, my lord.
Submit said this IA interlocutory application has become infractures. So therefore, she doesn't praise for
16 September.
Pressed the praise the application any further. Staff. This IA stands disposed of not dismissed as not being pressed. Okay. And CRP, Ms. Hinti Jaran Land Council for the petitioner is present. None appears on behalf. Okay, state is also there. So this will be listed after?
After 2 weeks, my lord. My lord, there is an interim which may be continued.
Okay. Yes, prayed for, by the Land Council for the petitioner, list the matter after 2 weeks. Start. The state is respondent here?
21.
No one.
No one.
Okay.
21.
List the matter after 2 weeks, The interim order pass earlier shall continue till the next date of listing. Okay. That is 21.
Supplies.
Below item 22.
Yes. 22.
We are proposing on.
Hearing will be, sir, difficult today.
Yeah.
No time, and then the election petition is fixed. That, so when?
16 of September.
16 September?
Yes.
Okay. Had Mr. Mukpatin, Land Senior Counsel, assisted by Mr. Tang, Land Counsel for the petitioner, so appellant. So also had Mr. Kodapa, Land Counsel.
Respondent number 2.
Okay, For state, who is appearing?
Yeah.
Okay, Miss L. Hage and Mr. Kodapa, Lana Council for L. Hage, Lana additional PP for the state and Mr. Kodapa for respondent number 2. Staff on the prayer of the Lana Council for the party, list the matter on
16th of September.
16th September. Okay.
My lord, item number 20.
Grateful.
Item
Criminal appeal. My lord.
23.
Yes.
Yes.
This may be, lordship, this may be fixed on 27.
Okay. On the prayer of Mr. K. Posik, Lana Council for the appellant not being objected to by Ms. L. Hage, Lana additional PP, comma, list the matter again, list the matter on
27.
27 September.
Yes.
Okay.
No. August.
27 August.
Yes.
Okay. Okay. Come
Obliged.
prepared.
Item number 17.
Just a minute, sir. 17 is election petition. Just a minute, huh? Yeah, call Kumar once. Nah. Just a minute. Well, just a minute, huh? Before starting, we'll take a break of just 2-3 minutes. Okay. Take something. 3 minutes. Okay.